Item number 16. Next Monday. List on Monday. Monday. It will be listed on Monday. Tomorrow I am having another. Monday will be 7th of August. One is not available today. No. Okay.
Your Ladyship, I will mention item number 7.
7?
Yes.
Yes.
Maybe this after 1 week.
List of students on list of.
Yeah, my lord. My lord, I beg to mention item number 13, madam.
13.
13, madam.
Yes.
On behalf of MK Singh, madam.
MKC is not available today.
He is out of station, madam.
Out of
And I
station.
have taken consent from other side also.
From us, yes,
Uh,
consent has been taken.
Matter may be fixed, my lord, after 3 weeks.
Government side. For this year.
Ah.
Matter may be,
And madam, there is an interim, it may be continued, madam.
matter may be what you have said, subsisted, matter may be listed after,
3 weeks, madam.
list after 3 weeks, interim will continue.
Public.
Today, if, in the court number 1, no,
Yes,
division
yes.
bench, 2 matters were there,
Yes, your lord.
criminal jail appeal.
Yes,
None
sir.
of the, you have not appeared.
Your lordship,
Yes,
actually,
sir.
because of the, we all were stuck in the traffic, your lordship.
Huh?
The case was respectively endorsed to the respective additional PPs. But however, your lordship, the concerned PP, even me, your lordship, we are stuck in the traffic. Because of that, we are unable to reach the court, your lordship. We really apologize for this, your lordship.
We were under the impression that the concerned additional PP, to whom the case has been endorsed, she would be coming and appearing before the matter. So under that impression, we were coming as per the time of the honorable court. However, my lord, she was stuck in the traffic.
What we apologize, deeply apologize for that.
Item number,
I'm sorry, my lord. Nowadays, the cost list, my lord, they're a bit confusing, my lord. Earlier, it used to come serially, my lord. Now it's been called 17.
calling because of.
Yeah.
because
Yes, yes,
it's
ma'am.
a motion column.
Yes, yes. No, my lord, in this case, my lord, the petitioner here in my lord, and the respondent in number 4, my lord, they had some business transactions within them, my lord. And the petitioner owed a sum of rupees 5 lakhs to the respondent number 4. And it was to be paid in October 2022, my lord. However, my lord, they had an agreement in presence of Gangura and other witnesses, man. As he could not pay the amount in time, so he was asked by the arbitrators to pay additional sum of rupees 50,000, man. So ultimately he paid 5 lakhs 50,000, and this agreement was done here in Naharlagan, man. Naharlagan. Not matter got settled, man. Now suddenly, my lord, he receives this notice, my lordship. We are challenging the notice that has been issued by the. Mara, this is totally illegal order, which is not at all sustainable. Your lordship may kindly see the notice. Order annex 1, page 16, Mara. Page 16, Mara. Kindly see who has issued the order, Mara. Top, Mara. Office of the All 02 Gambura and Gamburis Association. It's admitted in Arunachal, in the regulation 1945, village authorities are there. That is not being denied. And that village authority, that's Gamburas, they are specifically appointed for a particular village. If there is any civil dispute between the parties in a village, it will be settled by the Gamburas. That is, after the civil code amendment, also Gamburas have the power. Now what they are doing, when the that they cannot adjudicate cases which is beyond their territorial jurisdiction. Now, what these Gambura and Gamburis they are doing, they are forming an association within the district, madam, and extending their jurisdiction from village to madam, circle level. This is totally illegal, madam. That is not there under the law. They cannot act in such an illegal manner. Therefore, we are challenging. And now, kindly, I'll just paragraph 2 madam, of this order. Therefore, under the provisions of Section 30 of Arunachal Pradesh Regulation of Justice Act, actually 1945, madam, the following GBs are hereby appointed as arbiters heard and a money lending case in between Tauror and Sri Mating Tarkanu on 13 July 2008, 10 a.m. General Ground actually. Arbitrators, this has been given. Now, this Section 38 of Regulation Act 1945, that was the power conferred to the Deputy Commissioner. That was the power conferred to the Deputy Commissioner when to adjudicate in civil disputes. Section 38. Now, after a lordship wouldn't take to everything. Now, I have annexed our Civil Code Act, madam. Here it starts from page 20, madam. I'll take your lordship only to page 25, relevant portion, madam. Page 25.
Yes.
Amendment of Assam Frontier Administration Justice Regulation Act 1945, number 1 of 1945. Your lordship kindly come to serial number 5, madam. Here, 1 surplus part. Section 37, 38, and 39 shall be deleted, madam. First of all, this authority was conferred to the Deputy Commissioner. And it was earlier, it was the Deputy Commissioner who used to act under this section. Now, the power of Deputy Commissioner no more because it has been vested to civil courts now. Now, this has been deleted in the amendment, madam. How they are drawing this power, madam, by the village authorities, madam? After this, madam, what happened? This impugn order, madam. I filed a representation before the that authority saying that no, you don't have the jurisdiction to try this suit because first of all, the execution of agreement was done in Nahalagan. I reside in Kompo village. That the defendant number 4 resides in a different village. A person residing in 2 different places. How the village authorities of a particular place can decide the matter? That cannot be. If the respondent who wants to file a suit, he can approach a civil court. That is the proper way. But this authority, it cannot. Despite receiving that our representation, madam, this second notice, 18.7, page 17, this has been issued again. And same authorities, Office of All 02 Gambura and Gamburi's Association. Now, this association itself is illegal, madam. They cannot form such association and extend their jurisdiction beyond their respective villages. So, madam, this order is expressly illegal, madam. At this stage, we pray this honorable court to issue notice and suspend the proceeding, madam. This case, madam, which they have written, madam. And top page 16, madam, number YCL/HGB case /2023-101. This may be proceeding, may be state, madam. Totally illegal, madam. Now, madam, after that, and we have made the Deputy Commissioner was not a necessary party here, madam. But we made him as a respondent number 1 because the Gamburas are appointed by the Deputy Commissioner, madam. As per Section 4 of Regulation Act 1945, 5 of 1945. And it is the duty cast upon a Deputy Commissioner to put the Gamburas to act within their jurisdiction, madam. How did the Deputy Commissioner allowing them to exceed their jurisdiction, forming such association and harassing the public, madam? That's why we have made Deputy Commissioner as the party here for direction from this honorable court that he should, my lord, at least look after the function of the Gangburas and Ganguris, my lord, because he is the appointing authority. Otherwise, the deputy commissioner was not a necessary, I'm frankly admitting, my lord. But here we want the deputy commissioner at least supervise the Ganguras whom he appoints. Yes.
Your Lordship, notice may be issued in this regard. Right now.
Proceeding may be suspended, but that's all, my lord, at this stage. Totally, my brother will also agree. This is no, in no way the Ganguras could have acted in this manner.
It was the proceeding initiated by the Gambur Association. Your Lordship. The deputy commissioner has no, I don't know whether he has any idea or not.
But because deputy commissioner is the appointing authority under section 5.
Yes, that
said
is true.
already
Your
that,
Lordship.
You've been appointed authority of the Ganguras.
Yes.
So you may not be necessary, but if the formal parties are there, most probably formally.
Yes.
Yes, Your Lordship.
But what is the stage of this, after this notice? What is?
Now, madam, we have been asked to appear on a 3rd, madam. 3rd August, yes,
On?
3rd August,
So.
day after
every-
tomorrow.
But there is this dispute, but despite this order, the matter was fixed before the arbitration. The
Yes,
Arbitration committee.
yes,
There will be arbitrator most.
yes,
probably.
madam.
So.
No, but thereafter, madam, page 17, madam, 2nd order has been issued.
Hmm. Second notice.
Yes. Madam, type copy is page 19, madam.
Yes, yes, I have.
Page 90 is a type copy. Last, 2nd paragraph. Therefore, take note, this someone noticed that in default of your appearance on the next day fixed on 3rd August 23, civil complaint money suit will be heard and determined in your absence by this court of village council as power and provision conferred under Assam Frontier Administrative Justice Regulation 1945. Given under my hand and seal of the court of village level council, ma'am.
His name. His name is P. Heard Mr. Peter, Leland Council. Also heard Mr. G.
Vairam.
The government advocate appearing on behalf of this government. The present petition. is filed. Application is filed under Article 27 of Constitution of India. Praying for a direction to pause and set aside the interim order. / summon passed in case number YCL HGB case / 2023-01 dated 3/7/2023 and impugned second notice dated 18/7/2023 by all 02 Gaon Burha and Gaon Police Association which has been passed illegally and arbitrarily. It is submitted by the learned counsel for the petitioner. That as per as provided the as provided under the Arunachal Pradesh Regulation of Justice Act 1945. The village authority has the power to adjudicate the civil dispute, but every Gaopuras has his jurisdiction only over the village from which he belonged. But the present order / notice is passed by a notice is issued by the office of all 02 Gaon Burha and Gaon Police Association, which is by extending their jurisdiction over the entire circle, which is not at all permissible. And they do not have any authority to pass any such kind of order for the persons who belong to different villages. Also, it is submitted that the deputy commissioner may have the authority to pass such order instead of the Gaubra Association. Further, he submitted that after the amendment of the act, the 37, 36, 37, and 38 sections are being already deleted, and the power is vested on the civil court, and hence, in view of the amendment also, the Gaubra Association has no authority to issue such an order slash notice. Further, it is submitted that by the second notice dated 18/7/2023, the present petitioner was directed to appear before the association on 3rd of August 2023. In default of their appearance, it is stated that the matter will be heard in his absence. As per power and provision conferred under the Assam Frontier bracket of the Administration of Justice and Regulation Act 1945. Accordingly, it is submitted that if any adverse order is passed in absence of this so and so, accordingly it is submitted that they have challenged the order and notice issued by the said association, which is illegal and arbitrary, and accordingly prayed for stay of the order slash notice filed by the said association. Next, para in this context, the learned government advocate, so and so has submitted that he have submitted that the notice should be issued to the private respondent before passing any order in state. Considering the submission made by the learned counsel for both sides, and also considering the submission made by the learned counsel for the petition, the said notice of the order dated so and so and so and so is stayed till next date. Further, issue notice to the private respondent through registered AD and as usual process. Let the matter be accordingly listed after
4 weeks. After 4 weeks, madam, we have to give notice, madam.
after 4 weeks.
Yes. Not that, in the first line, not Arunachal, madam, it's Assam Frontier Administration. Plus
Sorry,
much of
right, will be right.
public.
Publisher.
May I lordship? Lordship, this petition has been filed under Article 227 of Constitution invoking supervisory jurisdiction of Honorable High Court. The fact of the case is that, Your Honor, the petitioners belong to Mismi tribe, and they belong to Mipi clan. This is a dispute between Mipi clan and Miu clan of Dibang Valley district, Anene. So, since 2017, this land dispute is stirred between these two clans. And after that, because of the dispute, the petitioners have submitted series of application before the DC for intervention, but the Deputy Commissioner Dibang Valley Aneni did not intervene. And finally, on 10/9/2021, District Magistrate Anini has taken up the matter and under section 145 of CRPC, directing the both the parties to maintain status quo. But the Miu clan, the respondent, did not maintain status quo by constructing house, dwelling roads, etc. So again, the petitioners file application before the DC intimating that the respondents are not complying the status quo order. But the DC have not taken any initiate any actions against them. So finally, Your Honor, on dated 29/6/2023, again, the petitioner have submitted application for intervention of DC underneath. So my prayer is that, Your Honor, a simple direction may be issued to Deputy Commissioner to intervene the matter and refer the case to Avela, to the village authority to conduct Avela. As Mismi tribe, Idu Mismi tribe used to call Gava as Avela.
So you have not made the deputy commissioner as a party.
No, Your Honor,
For
as
whom you are seeking a direction,
yes, Your Honor,
for whom you are seeking a direction that he should be intervened. Or
By
he should
DC.
make any intervention in this regard.
yes, Your Honor.
So, but you have not made party.
Your Honor, as he's an act in the power of magistrate.
Huh?
DC.
Ah.
DC is a magistrate, Your Honor.
No,
So-
wherever you have made respondents, two respondents are there.
Yes, Your Honor.
You have not made the DC
They-
as a respondent or deputy commissioner or executive magistrate, whoever. What? To whom it will be direction? You are seeking a relief or whatever you are seeking against the DC only. That he is not intervening, so the respondents are still violating the status quo order passed by the so and so.
Hmm.
So whether the deputy executive magistrate is made in party, I don't think so, it's not here.
As Your Honor, he is in court, so.
Huh?
As deputy
You
commissioner is
are
in.
here before any authority. I mean, the lead authority. So obviously, one has to be not paid party, otherwise to whom it will be directed. The deputy commissioner also may have to say something. So just think over it, and we are listing the matter only after next week. Just think it, if it is necessary, then file an additional affidavit. So that we
At
actually
least, Your
can-
Honor, at least notice may be issued, Your Honor.
To whom?
To the opposite parties, Your Honor, they
No.
are not complying, Your Honor.
They are not complying, but you want the direction to DC only. That
Yes.
DC, this intervention of DC should be there, so that the parties may maintain the status quo over the disputed land. That much only. That is the 227. So for that, you have to make a party, but otherwise whom it will be directed?
We have to make DC party.
I think so, otherwise whom it will be directed, because he or DC has to make something. The matter is between two private clan. That
Yes.
is understood.
Yes, Your Honor.
But you have approached the DC executive magistrate, whatever you have approached them with a petition, with the application, not only once, you have applied repeated applications before the DC concerned. He should made and be liable for explanation as to why he has not been intervening, even if the dispute is between is still going on. So I think let the matter be listed after 1 week.
On Monday, Your Honor.
I don't think Monday lots of cases are already been fixed. List after 1 week, registry will accordingly. I'm not giving you 2-3 weeks, that's 1 week only. Within 1 week, you just think over it and file an additional affidavit so that it can be, the matter can be disposed of in the day itself by making the DC as a party to this.
Yeah.
List after 1 week.
Right.
This is one petition. Quashing of the chair case number 496 of 2021. Petition has been filed jointly by spouses. This petition number 1 is the husband, 2 is the wife. The section charge is 498A IPC. So factually, this FIR was low on 16 June 2021. And subsequently, my lord, initially it was registered under section 498A 506. My lord. But my lord, thereafter when charge sheet was filed, 506 was dropped by the IO. My lord. And thereafter, my lord, on 27th of July 2023, parties have arrived into a settlement, my lord. Because, my lord, there is one minor daughter, my lord, who is of 4 years and 3 months old, my lord. As well as, my lord, these parties, they are still, my lord, living as a spouse, my lord. Therefore, they have settled the case, my lord. Settlement, my lord, will find the agreement at page number 34, my lord. This is annexure 3, my lord.
But the other parents are also, the parents of the petitioner too is also been made party earlier, or they are not the
No, my lord.
accused?
No, my lord. Only husband, my lord. And my lord, since case has already been charge sheeted, my lord, but the case is in the state of inquiry, my lord. It is only fixed for appearance of the accused person, my lord. So charges has not yet been framed by the London trial court below, my lord. And my lord, next date for appearance of the accused, my lord, is fixed on 18 August 2023, my lord. My lord will find this agreement, my lord, at page number 34, my lord. Third paragraph, my lord. May I read you, my lord? And whereas the first party has availed personal loans from some individuals in the name of family members of the second party is the husband, no, which was not paid in time, and the borrowers were harassing the second party. Moreover, the second party had also mistakenly entered into an illicit relationship with a woman, due to which the first party had left him and came to Itanagar residence. However, while the second party approached the first party seeking forgiveness for this illicit act and with request to clear the loan which the first party had taken, the first party, due to misunderstanding and deep anger, had closed the affair dated such and such. And whereas immediately after the losing,
He lost the FIR out of deep anger, and he entered into a illicit relationship mistakenly.
mistake, all of this entire allegation, Malad. Malad will find the FIR at page number 25, Malad. Type copy is at page number 26, Malad. Contents of the FIR, Malad. It will demonstrate, Malad, there was only an apprehension, Malad. Only apprehension. Just I made some attempt to physically assault my wife, Malad. And there was some allegation, Malad, that I am having some illicit affairs. So, Malad, this FIR was lodged on 12th of June, Malad. But immediately on next month, Malad, from July of 2021, Malad, we are still living as a spouse, Malad. Therefore, Malad, I have quoted some citation, Malad. Malad, this Bhajan Lal case, Gyan Singh case, Malad, as well as Lakshmi Narayan, Malad. Malad, my case squarely falls within the parameters of law which has been laid down in these cases, Malad. Because, Malad, since they have entered into settlement, Malad, for the ends of justice, Malad, as well as to abuse the process of the law, Malad. And, Malad, since they have already entered, conviction is completely blind, Malad. And going into trial, Malad, it will be completely futile exercise. But further, Malad, this offense is completely, Malad, private in nature, Malad.
Yes, Your Lordship, this is purely a matrimonial dispute, because the allegation in the FIR itself clearly says that the husband has an illicit relationship. So now, since they have settled the matter entirely among themselves, the parameter of Lakshmi Narayan case will cover it, Your Lordship. So what my fair submission is, Your Lordship may interfere in this matter, and since it's squarely covered under Lakshmi Narayan case. That's it.
Your petition will be, matter will be disposed.
Malad. Deeply obliged.
Obliged, Your Lordship.
Will be accepted.
After, Your Lordship, any day? After?
After
3 weeks, Lordship.
After 3 weeks.
3 weeks, okay. Much obliged.
Not after 3 weeks. After 3 weeks.
After 2 weeks. Obliged, Your Lordship.
Lordship, here we have already completed, our service has been completed. Since after filing of this case and notice was issued, neither of the respondent are appearing nor they are filing wakalat now. So matter was fixed for admission. Your Lordship.
Service is already complete.
Already completed.
For how many respondents were
There are total 5 respondents. Neither they are appearing nor wakalat nama has been filed. Your Lordship. So I pray that matter may be proceeded and fixed for hearing. Your Lordship. This is a civil revision petition. Your Lordship.
Heard Mr.
A. Bhattacharjee.
A. Bhattacharjee, the learned counsel for the petition. From office note, it reveals that the services already completed on all the respondents. But till now, they have not appeared to any counsel or nor filed any wakalat now on their behalf. After considering the submission made by the learned counsel for this one, so matter is admitted for hearing. This the matter accordingly for final hearing after 2 weeks. After 2 weeks.
Yes, meantime, Your Lordship, there is a interim pass earlier.
Interim was earlier passed, interim order.
They will continue.
Continued.
Obliged.
So you're appealing for, she's appealing for final respondent?
Yes, Lordship.
Yes.
Lordship, if I may. Lordship, this petition has been filed for quashing of the complaint case number 10 of 2022
Hmm.
under section 419, 420, 468, 471 of the Indian Penal IPC filed by the respondent number 2 against me, and it is pending before the learned Chief Judicial Magistrate Alo, Lordship. The crux of the complaint case that is filed before the Honorable CJM Alo is that the complainant contends that in the year 2004, Lordship, the complainant, the respondent number 2, who is the complainant in the case before the Honorable CJM, he contends that he had a plot of land, 2 plots of land. One was a WRC field, wet rice cultivation field, and one was a Zoom land cultivation. Now, what he has contended, the respondent has contended that in the year 2001, he had sold me a plot of, he has sold me the Zoom cultivation. This plot of lands are adjacent to each other, side by side. Now, what he contends is that he has submitted, he has sold me the plot of land in 2001 for a consideration of rupees 20,000. Now,
Zoom land.
Zoom land, only the Zoom land. Now, after in the year 2020, he receives a notice from the Deputy Commissioner Alo, saying that you are encroaching upon the WRC field. So he files a reply before the Deputy Commissioner saying that WRC field is mine. It is mine. It is owned by him. So accordingly, he comes to know thereafter. The projection made by them is that thereafter he comes to know that WRC field has been fraudulently purchased by me. If the respondent number 2, he filed an RTI and he procured some documents. Whereafter he came to know that in 2001, what I did was I not only purchased the Zoom land, but I also fraudulently took charge of the WRC field that belongs to him. Now what he did after that, he comes to me. He comes to me and then he requests me that I should make clarification before the DC Alo, saying that this land does not belong to me. So when I didn't give him any response, in 2020 itself, he files an FIR, but the FIR is not entertained. Then, constrained by the non-entertainment of the FIR, the respondent number 2 had to file the complaint case before the learned CJM, this Alo. And accordingly, cognizance was taken under section 420, 419, 468, and Lordship, this 468, 471 of the Indian Penal Code. Now, Lordship, the basic crux of this complaint, Lordship, there are two things to be considered, Lordship. If my Lord will kindly. Now, according to the story projected by the respondent number 2 in the complaint case, it is their categorical position that they had only sold me the Zoom land and not the WRC. And what they have did was they have misrepresented before the Honorable Court that they had no information regarding this sale till 2020. They say that they only came to know, they only made a statement that they were in possession of the plot of land since 1983, and they are still in possession. They have misled the Honorable Court regarding many facts, which may be highlighted now, Lordship. Now, Lordship, firstly, Lordship, if my Lord will kindly come to our petition, Lordship, page number 51, Lordship. Lordship, this is a sale deed agreement, and this sale deed they have also annexed in their reply as well. They are not disputing this. Now, according to this sale deed, Lordship, the respondent number 2 had sold me the WRC field, the Zoom land, back in the year 1994, Lordship. And this agreement, Lordship, was signed by witnesses, and it was also countersigned by the then Judicial Magistrate First Class, Alo, Lordship, at that point. Now, this is a registered document, Lordship. That is in my possession since the year 1994, Lordship. This. Now, Lordship, this agreement was executed between us in the year 1994. Now, suddenly in 2020, the respondent number 2 comes up and says that I was not aware regarding any this sale deed that was being made. I was not aware of anything, any sale transaction that has occurred between us. Now, what he's doing is he's disputing. He's saying that this document has been forged. Now, as my Lord is aware, Lordship, my Lord knows that when it comes to registered document, Lordship, there is always a presumption in favor of the person who has in a registered document that the registered document is valid, Lordship. Now, before the learned CJM court, Lordship, when cognizance was taken, we have also annexed the witnesses, Lordship, who were examined. Now, there were 2 witnesses they were examined before the learned CJM court. First is the complainant himself, and the another one is Sri Damning Pusang, a person named Damning Pusang. What he says is that in the year 2020, the respondent number 2 told me that fraud has been committed upon me, and then a fake 1994 sale deed is there. That is the only statement given by the witnesses one. Even the deposition of the this Lordship of the complainant in himself, if I may read the relevant portion, Lordship, I agreed and sold some portion of my land for construction of house for Sri Kenmar Kamsi, the petitioner, for an amount of rupees 20,000 as sale consideration. The land was sold in the year 2000. I asked him to prepare a money receipt, and I told him I do not know how to prepare the receipt. Then he took my signature in a plain paper. I received a notice from Office of Deputy Commissioner acting on complaint from Khartoum Loi and Karyom Loi Now, these two persons, Lordship, I had sold the land to these two persons in the year 2004. This K. Loi, Khartoum Loi and Karyom Loi, Lordship. On receipt of notice, I went to meet Kenmar Kamsi at Itanagar. He then assured me he'll sort out the dispute. Now, Lordship, the story that the complainant is trying to project is that the land was sold in the year 2001. He says that prior to 2001, there was no transaction between us. So in 2001, I sold the land. And what I did was, after buying the land in 2001, it is within my power that I could manufacture a document, Lordship, an original document, which has a stamp paper dating back to 1994, which is signed by a judicial officer that was appointed at that place of time in 1994. In 2001, I went and by some means, what I did was I executed a sale deed almost 16 years back, dating back 16 years back from a judicial magistrate. Nonetheless, this is not an agreement wherein only the witnesses are signing. It is countersigned by a judicial magistrate 16 years back. So their projection is that it is within my power that I can procure a sale deed countersigned by a judicial magistrate who was appointed at Alo in 1994 in 2021. Lordship. Now, Lordship, if I may. Lordship, if I may kindly read the relevant portion, page number 12, Lordship. Lordship, if I may, Lordship. Page number 12, para 32, Lordship. To appreciate the finding arrived by the courts below, we must first see on whom the onus of proof lies. The record reveals that the disputed documents are registered. Now, they are disputing the sale deed, Lordship, 1994 sale deed, which is a registered, Lordship. We are therefore guided by the settled legal principle that a document is presumed to be genuine if the same is registered as held by this court in Prem Singh and others versus Birbal and others. The relevant portion of the said decision reads as below. There is a presumption that a registered document is validly executed, a registered document. Therefore, prima facie would be valid in law. The onus of proof thus would be on a person who leads evidence to rebut the presumption. In the instant case, respondent number 1 has not been able to rebut the presumption. Now, Lordship, if the parameters given below here are applied to this case, if the cognizance order is taken into consideration, the cognizance has been taken on the basis of the complainant's deposition and the deposition given by one witness who is a hearsay witness. So now, even if the complainant's witness is seen, Lordship, he has not examined any of the witnesses who were the signatories of the 1994 agreement to prove that the agreement was not validly executed. He has not examined, he has not made any prayer to examine the judicial magistrate first class who had countersigned this deed. Basically, his only contention is that his signature has been forged. Nothing, only oral advertisement, nothing is there, Lordship. Now, Lordship, then the honorable CJM, Lordship, should have, if that be so, Lordship, if this document, if the genuineness of this document cannot be shaken, Lordship, if it stands, the veracity of it cannot be doubted, then the offense under 468 does not attract, Lordship. Neither does 420 attracts, because this agreement has a total description regarding, there is a consideration, there is a proper demarcation, there is a proper mention of the property. They are not even disputing that the property is not the same wherein the execution was, this agreement was executed about. This is the same property that is their, Lordship. They have been unable to shake the veracity. The registered document is valid. They have been unable to discharge the onus that was upon them to prove that. Now comes, Lordship, the delay in filing this instant complaint, Lordship. Now, if my Lord will kindly come.
Is it a civil matter?
Lordship.
It is not a civil matter.
Actually, Lordship, this is a civil matter. This has been given the color of a criminal matter.
You are on criminal matter now.
Yes, Lordship. Yes,
Lord.
Lordship. If my Lord will kindly come to, Lordship, page number 26. Now, page number 26, Lordship.
Page number.
26 of our petition, Lordship.
Hmm.
Pardon, Lordship. Pardon, Lordship, page number 53, Lordship.
53.
53. Lordship. If I may read, Lordship. Lordship, this is the order by the DC that was given to respondent number 2. Whereas a written complaint lodged by Sri Kartum Loi, son of so-and-so, and representative elder brother of Sri Karyom Loi, to the effect that on 4th January 2010 and 5th January, you have claimed some portion of the WRC field, which belongs to the applicant. And whereas you have executed a sale deed agreement on dated 27/1994 in the Court of Judicial Magistrate First Class in connection with sale disposal your land to Sri Kenmar Kamsi of Angu village under POPS Alo. And whereas you have already sold the land to Sri Kenmar Kamsi and Sri Kenmar Kamsi has sold the land to Sri Karyom Loi of Pakam village. Whereas it is reported that you are cutting the jungle and trees in the said land, which is illegal. Therefore, you are hereby directed to stop such illegal activities immediately, and in default, legal action shall be instituted to you as per provision of law. Now, Lordship, this notice, if my lord will kindly see, the agreement dated 27/1994 is mentioned here. This is dated 8 January 2010. And then there was a subsequent notice dated 5th November 2020, wherein which they have annexed in their reply, but which they have annexed in their complaint petition, but though they have not annexed this order by the Honorable the DC, the 8 January 2010 order before the learned CGM court, in order to create an impression that they came to know about this purported illegality that is being committed by me in the year 2020, Lordship. Now, if Lordship 2020, he knew from if the registered document is to be considered, he knew from 1994 that he has sold the land to me. Then again, he has taken the plea that he was not aware. But if this order is a 2010, if this is taken to be the mark wherein he came into knowledge about because he has submitted a reply. The respondent has submitted a reply to this saying that, and in there, he has very specifically mentioned that I have never executed any deed before any judicial magistrate, K. Riram. He has named the magistrate. That means, Lordship, that he has seen the deed, that which on the basis of which the title was to be claimed. If 2010 is to be considered as the benchmark from wherein he had the knowledge, the complaint case has been filed in the year 2022, Lordship. There has been a delay of 12 years, Lordship. Now, Lordship,
We lost the FIR on?
he lodged the FIR on 2020. That would be after 10 years. And even after lodging the FIR, he lodged a complaint in the year 2022. That is another nearly after 2 years. Lordship, para 5, Lordship, this page 5, para 16, Lordship. Now, Lordship, hearing the Honorable Supreme Court as in regards to inordinate delay in filing of complaint has observed that the court in Hasmukhlal D. Vora and Anand versus State of Tamil Nadu, that though inordinate delay in itself may not be a ground for quashing of a criminal complaint. However, unexplained inordinate delay must be taken into consideration as a very crucial factor and ground for quashing a criminal complaint. Now, Lordship, if we see there has been a delay of nearly, even if 2010 is taken as a benchmark, because his reply is of 2010, if it's 2010 is to be taken as the mark wherein he came to know, there is a delay of 10 years in filing the FIR and there is a delay of 12 years in filing the complaint. Now, his Lordship, the explanation he has given during the deposition, Lordship.
Para fine.
Pardon, Lordship.
You're on para?
The judgment, Lordship.
Yeah.
Yeah, para 5, Lordship. Page 5, Lordship. Para 16.
Page 5.
Apologies, Lordship. Para page 5, para 16, Lordship. Now, Lordship, his explanation to the inordinate delay has been given, Lordship, in his deposition, wherein he says, Lordship, if I may read, there is a delay in lodging complaint against the accused person for I was suffering from ailment and were undergoing treatment. I am deprived of my right on land illegally by the accused. Now, Lordship, he says he has been undergoing treatment for his ailment since 2010, 12 years, Lordship. There cannot be a justificable ground, Lordship, that he has been undergoing treatment for his treatment when he was able to do other things. As my Lord will see, he was fit enough to assault a Gaubura of the village. There is a cover order, Lordship. We have annexed data. Lordship, that order, Lordship. A translated copy is at page number 62, Lordship. Now, in the year 2013, Lordship, Kava was held between the parties, between the Khartoum Loi and the respondent Adil. Because Harbo Loi, Lordship, and the respondent number 2, because he has encroached upon the land of those people to whom I have sold the land. Now, Lordship, in 2012, Lordship, he was very healthy. He was wealthy enough. The allegation here is that he has assaulted the Gaubura. He went for clearing the jungle, and when the Gaubura approached to stop him from clearing the jungle, he assaulted the Gaubura. Now, Lordship, he was under no medical condition herein. He was fit enough to assault the Gaubura under the person. So that ground that he has taken, that the medical condition does not hold up, Lordship. Neither there was any medical documents that we could procure in the complaint case. We could justify that he had any ailment, which would justify treatment for 12 years, Lordship. That was not there, Lordship. Now, Lordship, even considering all the Lordship, the petitioner, Lordship, they have not come before the Honorable CGM Court with clean hands. They have projected a story wherein they are saying that from 2001, they have not, because we have annexed the whole petition, the complaint petition, along with our 482 petition, Lordship. Now, therein, Lordship, they have not annexed the relevant orders. They have not annexed they have annexed the sale deed, which was not legible. So the Honorable Court could not see what this was. They were in possession of the sale deed, Lordship. They had procured, because in their affidavit in opposition, they had provided a sale deed, Lordship. That was not given there. Lordship, they made a very categorical statement that they were in possession of the plot of land since 1983. When, Lordship, from the order dated 2010 itself, the DC has very specifically directed them that you do not have possession over the plot of land, therefore you are not entitled to them. So now, Lordship, they have not only misleaded that, regarding he has also made this, that there is nothing that he has projected a story like he is being dispossessed from the land instead of him selling the land to the petitioner lordship. Now, lordship, if in his petition, lordship, in his complaint case before the CGM, it is at page number 22, there is a para 15. If I may read, lordship, there is a small para. It says that further the complainant begs to state that as and when he came to know and received the aforesaid notice of 4 November 2020, he filed a right to information RTI to know the detailed complaint ground before the office of the Deputy Commissioner Alo, West Siang, AP. Accordingly, he came to know that the alleged accused person, Sri Kenmar Kamsi, the petitioner herein, have statedly sold out the entire wet rice field to Sri Karyom Loi on 31/1/2014 at the cost of 1,30,000 by showing the forced sale deed. Now, his projection herein, lordship, is that he came to know about this after an RTI or receiving a notice in 2020. However, lordship, in the same petition, he has given a reply to the DC, to the order dated 2010, wherein he has very specifically mentioned that I have not executed any sale deed. The sale deed has been signed by a so-and-so magistrate. I have never been before the magistrate. And very cleverly, my lord, what he has done is, although he has submitted a reply, but he has not submitted the order before the Honorable Court, the 2010 order, which we had annexed, whereby he was directed. Now, his projection is he only came to know in 2020. Now, it is this complaint is their own version. It is their own pleading. In their own pleading, they admit that I came to, in 2010 itself, I came to know that such and such sale deed has been executed. That is not executed by me, and that is there. However, in their complaint, they are trying to make they made an pleading on oath, saying that I only came to know about this after 4 November 2020, lordship. They have not approached, lordship, the Honorable Court with clean hands. They have misrepresented. Now the Honorable Court, while passing the cognizance order, maybe the Honorable Court did not consider this. These were not highlighted, and these were not before their knowledge, lordship. Lordship, I mean, the first para, lordship. Fraud avoids all judicial acts, ancestral or temporal, observed Chief Justice Edward Coke of England about 3 centuries ago. It is the settled proposition of law that a judgment or decree obtained by playing fraud on the court is a nullity and non-est in the eyes of law. Such a judgment decree by the first court or by highest court has to be treated as a nullity by every court, whether superior or inferior. It can be challenged in any court, even in collateral proceeding. And lordship, then para 7. The High Court, in our view, fell into patent error. The short question before the High Court was whether, in the facts and circumstances of this case, Jagannath obtained the preliminary decree by playing fraud on the court. The High Court, however, went haywire, made observations which were wholly perverse. We do not agree with the High Court that there is no legal duty cast upon the plaintiff to come to the court with a true case and prove it by true evidence. The principle of finality of litigation cannot be pressed to the extent of such an absurdity that it becomes an engine of fraud in the hands of dishonest litigation. The court of law are meant for imparting justice between the party. One who comes to the court must come with clean hands. We are constrained to say that more often than not, procedural court is being abused. property grabbers, tax evaders, bank loan dodgers, and other unscrupulous persons from all walks of life find the court process a convenient lever to retain the illegal gains indefinitely. We have no hesitation to say that a person whose case is based on falsehood and has no right to approach the court, he can summarily thrown out at any stage of the litigation. Now, Lordship, if to conclude, Lordship, if the case of the petitioner of the respondent number 2 is taken into account, his case is that he has only sold me at WRC this Zoom land in the year 2021. Then he came to know about, then what I did in the year 2004, I sold the WRC field, which was owned by him, to someone else in the year 2004. Now he came to know about my act in the year 2020, wherein he received a notice from the DC court saying that you should restrain yourself from doing any activities in the said land. Now from 2020, now he is trying to justify the delay in a manner by saying that he only came to know about the notice in the year 2020. Now immediately, now if 2020 is taken into as the mark, then there is not much of a delay. 2020 he files an FIR, and then 2022 he files a complaint. That is there. But what he does, he plays fraud on the honorable court by saying, by misrepresenting, by suppressing that he had received an order in the year 2010 from the DC, wherein he has Lordship. Lordship. Finally, Lordship, my dear.
May I please, Your Lordship? And for the respondent number 2. The facts that my learned friend has cited are a bit different from my understanding of the case, Lordship. Now, Lordship, he has totally based his case on the ground of alleged delay, Lordship. But Lordship, that complaint against me, which was made by Khartoum Loi and another person who claimed to have bought my land from the petitioner, they had filed a complaint against me, and therefore those orders were passed, Lordship. But Lordship, after that restraining order, Lordship, that case never culminated into a final order, Lordship. There was no, Lordship, I had made a representation also, nothing was done, Lordship. Therefore, Lordship may see in my affidavit of opposition, page 33, I had made an application to the Deputy Commissioner to reactivate that case, and that was refused, Lordship, page 33, Lordship. Additionally, I had also filed a complaint before the police, which was not entertained, Lordship. Now, Lordship.
The question is as per him.
Yes.
You got the information, or DC had passed the order in 2010.
Yes,
So
Lordship.
why you waited for 10 years?
Yes, Lordship. Lordship may see, I never had a document, Lordship, although they alleged that they had bought the land from the petitioner. They means the third parties, the Loi parties, that they alleged that they have bought the land from the petitioner, and that the petitioner had bought the whole land. My contention is the land which the petitioner bought is only of 300 square meters, which is the Zoom land. And that was bought not in 1994, but in 2001. Now, Lordship, in the reply that I have made in 2010, page 27 of my affidavit, Lordship may see at page 28 also, in the third last paragraph, I have categorically stated, if there is any such document Therefore, I declare and deny I have not signed any sale deed document. If there is any such document, it will be treated as false. Now, if I did not have the copy of the document, I just heard that they are relying on that, Lordship. But since the case was not proceeded further, Lordship, that I did not get the copy of the document, Lordship. Now, Lordship, time and again, my learned friend has said that there is a presumption in favor of the validity of the document, Lordship. My learned friend has stated time and again that there is a presumption of validity in favor of the document, Lordship. But I have made an RTI application. If indeed that document was a registered document, then in reply to my RTI application, which is at page 34, which I have mentioned in my deposition also, page 34 of my affidavit, Lordship, last page, you Lordship may see. I have, if indeed it was registered, why was that document not in the office where it was supposed to have been registered, Lordship? They categorically denied that it is not available in the office, Lordship. This is page 34 in reply to the RTI, Lordship. Now, Lordship, most interestingly, Lordship may see from the petition, first of all, Lordship, from my complaint, which has been annexed in the petition, in his petition, Lordship, page 19, Lordship. Lordship may see the signature, Lordship. Page 19, this is my signature, page 19 onwards, the whole thing, Lordship. Then Lordship may see the deposition, Lordship. This also is annexed in his document, in his affidavit. Lordship may see the deposition before the court. Lordship may see the signature, my signature here. Then Lordship may also see the signature which I have made in my affidavit in opposition, page 17. These are all similar, Lordship. What is not similar is the question document, Lordship. Now, Lordship may see the question document. The question document is at page 24 of my affidavit in opposition, which they have also annexed, Lordship, the agreement dated 1994. Lordship may see the signature in page 24 of my affidavit in opposition. They have also annexed this, Lordship. As my Lordship found, page 24. Lordship may see that below, Sri Tako Koje. Lordship may see the signature. This is the only signature which does not match with the rest of my signatures, Lordship. Prima facie, it appears to be a clear-cut case of forgery, Lordship. Now, Lordship, only on the ground that there were purportedly some delay in filing the complaint, can this honorable court quash the proceeding, Lordship? That is my question, Lordship. Even without a signature handwriting expert, even on a bare naked eye, it is visible that it is different. The only different signature in whole of the documents is the question document, Lordship. Now, Lordship, Lordship knows very well what are the grounds for quashing a complaint. This has been, Lordship, held by the Supreme Court time and again, Lordship, starting with the state of Haryana versus Bhajan Lal. Lordship is very much aware of that. 1992, Supply 1 SCC 335. I may not even read that, but Lordship, just for the convenience of this honorable court, para 103 and 102 and 103. This the Supreme Court has laid down the parameters. Only if on the bare perusal of the materials on record, it is very clear that there is no case at all. There is a flimsy case and there is no case at all. These are two different things, Lordship. There may be a case which is not very strong, I would say, but if there is some case, it is only the prima facie satisfaction of the court that there is some case that it is that cognizance may be taken. It is not the same case as conviction, Lordship. I will like to read out para 103 and 102 and 103. In the backdrop of the interpretation of various relevant provisions of the code under Chapter 14 and the principles of law enunciated by this code in a series of decisions relating to exercise of the extraordinary power under Article 286 and inherent powers under Section 482 of the code, which we have extracted and reproduced above, we give the following category of cases by which illustration, by way of illustration, wherein such power could be exercised to prevent abuse of the process of any court or otherwise to secure the ends of justice, though it may not be possible to lay down any precise, clearly defined and sufficiently channelized and inflexible guidelines or rigid formula to give an exhaustive list of myriad kinds of cases wherein such power should be exercised. Where allegations where allegations made in the first information report or the complaint, even if they are taken at face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. Where the allegations in the first information and other materials, if any accompanying the FIR, do not disclose a cognizable offense justifying investigation, this I am not reading. Then 3, where the uncontroverted allegations made in the FIR or complaint and evidence collected in support of and do not disclose commission of any offense. It does not say commission of an offense, but any, lordship. Any meaning there shouldn't be anything which shows that there has been offense, lordship. Now, these are some of the illustrations, lordship, in which this honorable court can interfere, lordship. The case is to be a clear-cut case where there is nothing, absolutely nothing on record to show that some offense may have been committed, lordship. I'm also relying, lordship, just one, lordship, 2012, volume 9 SCC 460. I'm relying on paragraph 27. Here also, lordship, the scope of interference under 482 CRPC in such cases have been laid out. I'm going to read 27.3. This is also one of the illustrations. The High Court should not unduly interfere. No meticulous examination of the evidence is needed for considering whether the case would end in conviction or not at the stage of framing of charges or quashing of charges. Then 27.8, the last paragraph, lordship, where the allegations made and they appear from the records annexed here with to predominantly give rise where the allegations made and as they appear from the record and documents annexed therewith to predominantly give rise and constitute a civil wrong with no element of criminality and does not satisfy the basic ingredients of a criminal offense, the court may be justified in quashing the charge. Even in such cases, the court would not embark upon the critical analysis of the evidence. Now, this what my learned friend is asking this court. Shall we continue at 2, lordship? Shall I continue, sir? What my learned friend is asking this court to do is that why have you not examined the other witnesses to the document, to the question documents? The question document is probably signed by his party, his people. How does he expect them to give me evidence? In any case, lordship, regarding this, the Honorable Supreme Court has said in 2010, volume 7 SCC 578, that Section 202 of the CRPC, although the word shall is used, it is not mandatory. It is not mandatory that all the witnesses have to be examined. All the listed witnesses have to be examined. If the court is satisfied with just 1 or 2 witnesses, the court cannot be questioned just because he or she has not heard all the witnesses before coming to that conclusion, lordship. May I read, lordship? I'm relying on paragraphs 18, 22 to 27 and 32. Lordship. The expression sufficient ground used in 202, 204 and 209 means a satisfaction that a prima facie case is made out against the accused person of committing an offense and not sufficient ground for the purpose of conviction. The interpretation of the provisions in chapters 15 and 16 CRPC finds adequate support from the judgments of this court in Ram Gopal, Ganpati Rai Rao, and etc. Lordship. Then Lordship, para 22 Lordship. The use of the word shall in the provision to 202, section 202, subclause 2 is a prima facie indicative of the mandatory character of the provision contained therein, but a close and critical analysis along with the provisions contained in chapter 15 and sections 226 and 227 and section 465 would clearly show that non-examination or not of any or some of the witnesses cited by the complainant itself is not sufficient to denude the magistrate concerned of the jurisdiction to pass an order for taking cognizance and issue of process, provided he is satisfied that a prima facie case is made out for doing so. So basically, if the magistrate is satisfied that there is a prima facie case, then just because some witnesses have not been examined, because let us remind ourselves, the magistrate is looking into the matters not for the purpose of conviction, but for the purpose of whether or not to proceed with the case, whether or not there is a prima facie case. Now, if the magistrate says that he is satisfied with the witnesses which were presented, only on that ground, proceedings cannot be quashed just because some witnesses have not been examined. Now, Lordship, in conclusion to this, the Honorable Supreme Court has said at paragraph 32, as a sequel to the above discussions, we hold that the examination of witnesses cited in the complaint or whose names are disclosed by the complaint in furtherance of the direction given by the magistrate in terms of proviso 202 is not a condition precedent for taking cognizance and issue of process against a person as named as accused. And that is all, Lordship. So basically, it is not a condition precedent that all the witnesses have to examine before taking cognizance. The prima facie satisfaction is enough, Lordship. Now, regarding the delay, Lordship, which he has cited time and again, Lordship, the Lordship knows that starting with A.R. Antoli case in 1992, it was held that undue delay can be a ground to quash a criminal proceeding. Now, starting with that, then come the Supreme Court had in fact granted some direction in Common Cause Society versus Union of India in 1996 that it could be one of the grounds to discharge the accused. Now, Lordship, by Constitution Bench in 2002, Volume 4 SCC 578 in P. Ramachandra Rao case, your Lordship knows very well. The Honorable Supreme Court has deleted that ground of quashment on the ground of delay, only on the ground of delay, as given in the directions before, Lordship. Now it is very clear, Lordship, that delay by itself cannot be a ground to, Lordship, delay by itself cannot be a ground to quash the proceedings, Lordship. Not leave alone the magistrate. It is apparent from the records itself that this document is, even to the naked eye, like I submitted, that this document is false, Lordship. Now, in such a situation, just because in 2010, the respondent came to know, but he did not have the document. I repeat again, he did not have the document. He got it on in 2020 when he filed a police case. Then it was not interfered, Lordship. So only on the ground can the quashment be done, Lordship, because it is only in extreme exceptions that quashment is done, Lordship. The courts if he says that some other that delay is a ground, that these are things which can be taken at the time of the trial. These are things which can be taken as a defense, Lordship. It cannot be, we cannot be fighting over this in a quashment proceeding, Lordship. Obliged.
Submit this regarding the quashment. Delay should not be a matter of question.
Yes, I have submitted, Lordship. I have submitted the citation 2002. 2002, I have submitted in fact 3 citations. 2002 volume 4, then 2004 volume 6, usko bhi. Then 2009 volume 16. I'll mark it and give it.
I'll hear after that.
Madam.
2004, 6.
46574.
Page 574.
574. Your Lordship will see in paragraph 3, this is the, yes, paragraph 3 is the crux of the matter, that is that the petition under 482.
Paragraph 3.
Let me see.
What is the name of the
Harnam Singh.
Huh?
Harnam Singh versus Everest Construction and others.
your page number is correct? There is a 574, but
574, yes. 2004, volume 6. ठीक है. I have,
HPA International, no.
no. I have printed this out from the SSC online. Seven 5-4. Sorry, Lordship. Your Lordship will see in paragraph 3 is this is the facts of the case, that it was a petition under 482 for quashing of a criminal complaint before the Delhi High Court. Now, the Delhi High Court had quashed the complaint on the ground of delay. Now, the Supreme Court said on this that it appears there are two questions. One was about 195 CRPC and other regarding limitation. The High Court simply said that at this belated stage, it was, however, the complaint was quashed only on the ground that it is not maintainable at this belated stage. The learned judge thus observed, I am of the view that the complainant, being aware of the fact that the agreement dated 13/10/1980 has been filed before the High Court on 8/7/1991, that is after 10 years, cannot maintain this complaint at this belated stage in respect of a document which was filed along with written statement for defense by the petitioner in a suit pending at the relevant time at the High Court and is being adjudicated upon. So he says that that document, against that document, after 10 years, you cannot file a complaint. Because of that, the proceedings were quashed by the Delhi High Court. Now the Supreme Court overturned this decision in paragraph 6, Lordship. The Supreme Court said that we are unable to perceive any legal basis for the observation quoted above. The bar against cognizance after the lapse of prescribed period of limitation is laid down in section 468 CRPC. It is within the parameters of that provision that the court is called upon to take cognizance of the offense, that the court called upon to take cognizance of the offense should act. Most of the offenses alleged against the respondents, that is sections 420, 467, 471, and 474 are punishable with an imprisonment for a term exceeding 3 years, and therefore as contended by the learned counsel for the appellant, the bar of limitation under section 468 is not attracted. The complaint cannot therefore be thrown out at the threshold on the ground of limitation if apart from the question of limitation, this is important, Lordship, if apart from the question of limitation, the effect of delay, if any, in instituting the complaint is necessary to be determined for considering the merits of the charge, that can only be done at the stage of trial on the basis of the evidence on record. So, Lordship, it is not that they are forbidden from raising the ground of delay, Lordship. Lordship, I'm also relying on Lordship, another one, Lordship. I will not read this, but Lordship will see 2009, volume 16, 2009, volume 16, page 392. In this para 3, Lordship, in this para 3, the Honorable Supreme Court has held that the earlier decision in which, earlier line of decision, so to say, in which proceedings are quashed on the ground of delay, that is no longer a good law. That is already, that is reflected in this paragraph. And it has been said that unless there is an error apparent on the face of the record, mere lapse of time ought not to be permitted for intervention of the writ court to quash a proceeding. So just because there is a lapse of time, that is not a ground for quashing a proceeding. That is in paragraph 3, Lordship. So in order not to take up so much of time, I've not read out the paragraph 3, Lordship. So, Lordship, it appears that from the submissions made by the opposite party, it appears that from the submissions made, it appears that they are striking at the so-called merits of the case, which would otherwise, the merits meaning the so-called delay, then that there is no, that the offense was not committed, that I have made some wrong statements, those sort of things which were that I am not believable, that they were not enough witnesses. These are things which are touching upon the merit of the case. Can they show from the documents that there is no case at all? Your Lordship has seen on the face of the record itself that the signatures do not match. In such a case, can this court only on the ground of delay quash the proceedings? This is not a civil case. In criminal case, it's already given in 468 that a certain time in which cognizance can be taken. So in my humble submission, this is not a proceeding. This is not a proceeding which can be, this is not a case for quashment under section 482. So in my humble submission, this may be set aside and, this may be dismissed and let the trial court proceed, Lordship.
Your part is already almost
No,
over,
Lordship,
I think.
only one clarification I wanted to
Because
do.
already time is also hearing and there.
Yes,
So
Lordship.
no need for repetition.
No, Lordship, only regarding the signature, that part only, Lordship, on
Yes.
based on records.
My lord, since this state is a performer party in this case, since the fact of the case has been narrated by the respective counsel by both the parties, my lord, I will make a very limited submission. Firstly, may I take my lord to page number 51, my lord. I won't read the contents of the document, but I'll just see. This is the sale deed agreement, my lord. From this sale deed agreement, it can be ascertained that the land in question was sold by the respondent to the petitioner on 27/1994, my lord. And secondly, the sale deed was executed in presence of 4 witnesses and duly countersigned by the JMFC alone. Now may I take my lord to page number 62. This is the type of copy, my lord. This is the KEBA decision which was conducted, my lord. From this decision, my lord, it can be ascertained that the allegation that the complainant did not sell the land
to one Sri Kenmar Kamsi has been declared wrong by the village authority, my lord. Alleging that the respondent did not sell the land to the petitioner has been declared wrong by the village authority in this case and imposed a fine of ₹20,000 for making an allegation against the village authority. And thirdly, my lord, page number 21, back to page number 21. This is the translated copy, my lord, the sale deed. The sale land in question, my lord, was resold by the petitioner to one Shri Karyam Loi in presence of 5 witnesses, which includes the head Gangpura, my lord. So far, my understanding is concerned, my lord, there's no dispute with regard to the sale deed is concerned, my lord. It has been clarified that as per the sale deed, my lord, the respondent has sold to the petitioner and the petitioner subsequently has sold to the other party. Now, that is the factual aspect on the part of the report, my lord. Now, my lord, page number 49 is the impugn order, my lord. To my understanding, my lord, whenever a complaint case is being filed, my lord, I'm repeating the submission, my lord, on the last day also had a similar nature of a case, my lord. Whenever a complaint is being filed, my lord, the magistrate can take recourse to 3 options, my lord. Firstly, my lord, as per the provision of section 200, take the deposition of the complainant and the witnesses, if any. And accordingly, if a prima facie case is being found, cognizance can be taken. And if it's a summon case, issue summon. If it's a warrant case, issue warrant, my lord. And secondly, my lord, 202 of the CRPC postpone the issue of process or give a direction to the investigating authority or the inquiry himself, my lord. And the provision under 203 can dismiss the complaint, my lord. Regarding the inordinate delay in filing the complaint and non-disclosure of the facts, my lord, this aspect has been submitted by both the councils and the various authorities has also been submitted by them, my lord. Therefore, to that aspect, my lord, I leave it to the discretion of my lord.
Lordship, a small clarification regarding the submission made by respondent number 2, Lordship. If I may, Lordship. Lordship, the respondent number 2 have shown the signatures of the complainant. Now, in page number 67 of our petition, this is signature of this respondent number 2 that is there. But if my lord will see the page number 28 of their affidavit in opposition, the signature is quite similar to what was the signature that was given in the 1994 deed, Lordship. So now the complaint, the respondent number 2 hearing, now after 12 years, he is signing in a different manner. He was not signing in the same manner when the said was, it is on record, it is their own documents wherein his signature is different from what the signature is using right now. Right now, Lordship. And Lordship, one more thing I had missed, inadvertently could not point out was that there is a title suit filed by the respondent number 2 against me before the Civil Justice Senior Division ALO for declaration that this title, this 1994 deed is invalid. That is a title suit already. So they have already availed the civil remedy that was before them. And lastly, Lordship, if they are title suit number 12 of 2022 before the civil 22.
It is also within the same year the complaint was filed.
They have availed. We are the same.
Same year, it is not that it
Same.
was filed much earlier.
No, we are not making that submission. It's 2022 only, Lordship. And Lordship, lastly, Lordship, if prima facie, what they are saying prima facie, Lordship, on one hand, we have this document as we have reiterated, and on the other hand, he has on record, there are 2 signatures. One signature that matches the signature that he has made on 1994, and now he's using a different signature. And on the other hand, we have a registered document wherein they have been unable to discharge their burden, Lordship. That is our conclusion.
The question of burden, Lordship, will come during the trial, Lordship. Let the question of burden
But
come
Lordship,
during
one cannot
trial.
be, a person cannot be asked to withstand trial only if nothing is there, Lordship. It is someone's dignity is on the line, Lordship. To attend court, Lordship, as an accused person, Lordship. That may be kindly considered, Lordship.
I'll pass you, it will be understood.
Much obliged.
Organize. Very loose. But you see, let's see, and do that.
Maybe so.
Now we are going to admit this one because we haven't, it has to be heard. So I don't think I can hear you. This petition cannot be heard. I think it will be admitted. Both these petition. Basically, what, under what section the case was raised?
376, Your Honor, IPC,
376.
376. The informant is a sister and the eligible person is brother.
Sister?
Step.
Sister
Safe sister.
Yes.
Safe sister.
They have come before my
with the
lord
same
by
family.
way of a joint petition, my lord,
Yes, my lord.
but the record says otherwise. my lord.
And my lord, this case come to through the Aplaza and then after the registry of the legal aid council. I am the legal aid council from the both the side. The petition is the victim and informant herself along with the eligible person. And that this mutual agreement made by the in presence of the father of the both the daughter and the son, which I already enclosed in the page number 73, annexure E, my lord. So, my lord, I'm not going to run the merit of the case, my lord, because the merit is very stated before the in the charge sheet, my lord. But I'm only goes on the mutual settlements, which is invoking under section 482 of the CRPC, my lord. And regarding the fact of the case, I've not gone through the date, my lord. I just
Matter was heard earlier.
Yes, my lord.
Then what? Order was not passed.
No,
Not
no,
passed.
it was
Actually,
fixed for
I'm-
admission, my lord.
Huh?
It was fixed for admission. But even if we hear this matter, my lord, if we go through, peruse the confessional statement and the statement under 161, as well as the confessional statement of the victim, my lord. To my understanding, my lord, no authorities of Supreme Court or the High Court will rescue this case, my lord. Will save this case, my lord. Clear case of 376 of his own stepsister, my lord. There's no possibility of succeeding this criminal petition, to my understanding.
my lord,
It's very serious offense.
my lord, I admitted that this is a very serious offense, heinous crime before the society, my lord. But the main thing is that, my lord, the both is party with the same family member, and this the mutual settlement
That is
is
the main concern.
Yes, madam.
It is same family.
same family
That is
member.
the main concern for us.
Yes, my lord.
Even if
And-
you say the girl would have been from different family, that matter would have been to some extent different because it is a case within the family.
That's
That
true.
is the main concern.
Because for this concern, man, I have the two judgment also, my lord, where the honorable the apex court along with the honorable court of the Punjab and Haryana, Chandigarh
These two
district,
we have already filed, I think, yeah? These two.
which is my lord.
One is one.
One was is my lord, the High Court of Punjab and Haryana, Chandigarh is case name is Chandan Paswan versus State of Punjab and another.
Chandan versus.
Yes, Chandan Paswan, my lord.
Oh, no, these are different. Okay, yes.
And another is Kapil Gupta versus State of NCT, Delhi.
Kapil Gupta versus, yeah, it is here.
In these two judgment, my lord, the honorable courts is clearly stated that if the settlement between the parties is made with the will, concern, and mutually harmony between the two parties, then honorable court is have jurisdiction to quash this matter for the welfare of the parties and harmony of the parties, my lord. Because fact of the case and merit of the case I have not discussed because this matter is not the appeal and the revision. The trial is pending before the honorable session court. The CC already done the trial not be commenced, my lord. In the
Charge has already been framed.
charge already framed, my lord. In 8 of this month, my lord, the matter is to take as a PW's, my lord. So now commencement of trial is going on before this date, my lord. So I just humbly pray this honorable court that first of all I rely upon the first judgment in the High Court, Punjab and Haryana. The reliable portion is that, Your Honor. Page number 4, page number 2, paragraph 4 to 4.
Page number. Para 4.
Para 4, my lord, in my judgment. The judgment is Chandan Paswan versus Punjab.
Yes.
And yes, my lord.
You're relying on para 4, 5,
Para 5.
and 7.
5, 7, my lord.
Yes.
And last one is 8, my lord. And then after, my lord, this is the
What is
reliable
the
judgment
observation?
and the portions. And another one is, my lord, Kapil Gupta versus State
What
of.
is the observation? Which court now?
Yes, madam. Yes, Your
The
Honor.
Punjab and Haryana. Which court?
One is Punjab and Haryana. Second one is, Your Honor, Kapil Gupta versus State of NCT of Delhi.
Hmm.
The Honorable Apex Court is passed in the year of 2022. And the reliable portion is, Your Honor, my lord, paragraph 13, 14, 15, 16, and 18, my lord.
What it says?
Yes, my lord.
What is the observation here?
The main observation, my lord, seen in the paragraph 13, my lord.
Hmm.
May I read? It can thus be seen that this court has clearly held that though the court should be slow in quashing the proceeding wherein heinous and the serious offense are involved, the High Court is not foreclosed from examining as to whether there exists material for incorporation of such an offense as or as to whether there is sufficient evidence which, if proved, would lead to providing the charge of for the offense charged with. The last paragraph, last point is the court has also to take into consideration as to whether the settlement between the parties is going to result into harmony between them, which may improve their mutual relationship. The main concern is this manner, the harmony of the family member. On that context, the Honorable Supreme Court is quashed the matter. So, and relevant portion also there, the 14 to 18 is there, my lord. So on this context, my lord, I humble pray this honorable court, my lord, both are brother and sister, my lord, and in their family member, they are mutually settled the matter, and the dispute in page number 73 in my petition, my lord, annexure E, the deed of mutual settlement between the parties already done, my lord, and whatever the stated, this thing is strictly maintained by the both the parties, especially for the petition number 2, Eli's accused person. And the father also and mother also tried that this matter has never been happen in near future also. Because this is a family member, the reputation also dear. And sister or informant victim personally also stated that there will no any go to the any future context of the matter, my lord. Because this trial method goes on, then definitely some reputation is also questionable, my lord. And the family member also harassed. So I humble pray this honorable court that because of welfare of the family member, because welfare of the reputation of the family members, my lord, may kindly allow my petition and quash the trial presently going on before the honorable court of the session district judge Alo, and set aside the present the charge sheet in matter, which is already before the session court matter. This matter submitted.
My lord, may I take my lord to page number 25, my lord. It's a confession statement.
35.
25, my lord. This is the confession statement of the accused, my lord. The relevant part would be starting from page number 27.
27.
27. I'll start from question. What do you want to confess? I'm an educated unemployed youth having degree of BTech from Karnataka. The victim is my adopted sister who was raised by my parents with us since childhood. On the day of incident, I was engaged with my sister for many reasons. Firstly, she did not lock my room when I left for my native village, Tamariba at Dampurijo, to attend family picnic, social function and volleyball tournament, though I clearly instructed her to lock my room and paid some of rupees so and so to buy lock and key. Secondly, I found some of my song writing materials were not in proper place and same was lightly misplaced. I was writing songs for many years and those songwriting materials are lifetime work of mine. Thirdly, I doubted my sister might mismanage the income of my mother's shop located near General Hospital, Alo, which was looked after by her, as she and my mother often used to quarrel about the income of the shop. My sister used to recharge from the customer from the same shop, but the recharging business was also discontinued by my sister. Reportedly, rumor was going around that I and my sister are having a so-and-so relationship. I suspected my sister might spread the rumor. Fifthly, she was not keeping her house clean and she used to roam here and there. In fact, she was not performing household activities which were supposed to be performed as a good girl. I came back to Alo on so-and-so after attending the program at so-and-so village, and I reached home at around 10:30 a.m. After washing the car of my younger brother, which was used by me to attend the program. On many occasions, I advised my sister to be a good girl and to do positive works for her future, but she did not listen to me. She was raised by my parents along with us, so I trusted her as my own sister, but she has not followed my instruction and guidance. My educational documents, songwriting materials, and other documents relating to my business plan and to run NGO were there in my room. So I instructed my sister to lock my room and gave money to her to buy lock and key, but my room was not locked by my sister. I found my songwriting materials little displaced. Therefore, I went to room of my sister at around 4 p.m. to 5 p.m. I pushed her to her bed and removed so-and-so. Thereafter, I removed my clothes and then so-and-so, so-and-so, sister at around 30 seconds, 1 minute. After that, I so-and-so outside the so-and-so. She had asked me not to have a sexual intercourse with her, on which I instructed her not to make noise. I also pressed her so-and-so. After having sexual intercourse, I asked my sister whether she has money, as I was supposed to return rupees 3,000 to my friend, namely Damrik Ete. Moreover, I was not having money and so-and-so. This is the confessional statement of the accused, my lord. Now I take my lord to the confessional statement of the victim, page number 34. I'll start from second paragraph, my lord. The name of my brother are Sri Pege Game, Sri Pege Game and Sri P Game. Sri Pege Game completed his civil engineering degree from Tamil Nadu. At the time of the incident, I and my brother Sri so-and-so were alone at home located at medical colony behind district CGM court Alo. I was suffering from fever and body ache, so I was taking rest in my room after having painkiller medicine by bolting the door from inside. Meanwhile, Sri Pege Game knocked at my door and asked me to open the door. Accordingly, I opened the door as usual. Thereafter, he came inside my room and sat down on my bed. He said, "I'm doing too much." Then I asked what did with him by addressing him as Brother Ruka. He said that I'm not his sister. Thereafter, he unbuckled his so-and-so and then pushed me on my bed and then so-and-so. I resisted and refused to have sexual intercourse with him, but he showed his fist with extreme angry face and said that he will kill me if I make any noise. He directed me to remain silent. Otherwise, he will physically assault me after removing my so-and-so and so. He is so-and-so. Which I begged to stop as I was feeling pain, but I did not obey my request and continued. After raping me, he forcefully took my ATM card and mobile phone and directed me to come with him to ATM booth to withdraw money. Upon my refusal to go with him, he tried to assault me. He again directed me to follow him to ATM booth located at Pakutrai Junction without making any noise and threatened to assault me if I do not obey him. So I accompanied him and withdrawn some of rupees so-and-so as instructed by him. Thereafter, we returned back to her home and he left taking key of my scooty. He also locked me from outside. I was shocked as I was raped by my own brother. So I started crying and called my mother and informed her about the matter. Thereafter, I again called one of my brother and so-and-so. This is the, my lord, confessional statement of the victim as well as the accused. My lord. Now, if they are referring to Kapil Gupta, my lord, three aspects has been decided by the Honorable Supreme Court. Timing of the settlement, even though the offense is serious or heinous, but the High Court is not foreclosed from ascertaining the material on record. But so far, the present case is concerned, my lord, there is enough material to convict the accused, my lord, this case. So therefore, considering all this aspect and the nature of the offense, my lord, though they have come up by way of a joint petition, my lord, may not be considered by the system.
Pass the order today itself.
Yes, my lord.
I'm going to pass the order today itself if time permits.
Much
It will
obliged.
be disposed of.
Yesterday, bail matter,
Further, I am not going to hear, I think.
lordship, bail matter was pending, lordship, yesterday's bail matter.
Bail matter will be heard. Under one criminal petition, you are appearing.
I am appealing
Number
for
4,
Lordship.
petition number, item number 4, you are appearing.
For
Item
bail,
number,
bail, lordship.
No, I am only for bail.
we are doing. You are for item number 4. Item number 4. For item number 4. You give it to me. Bail application. Yes, bail application.
Ten or 22 lordship.
Yes, you have now.
Lordship. Mr. Lordship, the statement is also there, is the witnesses statements is there, Lordship.
Okay.
And Lordship, in the CD Lordship, it is found that this present accused Lordship, he's already booked in another Lordship case also. He's a habitual offender. There are 2-3 cases already been registered against him, Lordship, in the different district of Assam, as reportedly got to know during the investigation. Like Lordship 365, 307, yeah, IPC like that. So it is already in the CD Lordship.
But we are on the question.
Lordship, just I'm
Yes,
saying
it is
Lordship.
a
Yes.
case under section most probably
27.
intermediate.
Lordship, Lordship here, Lordship.
But
actually-
apart from the intermediate quantity, one section is added, that is the 27A. We
Lordship,
are on
27A Lordship, it is Lordship, this CD Lordship, it is a material is their Lordship, because the witnesses Lordship, they have also like in their statement, they have stated that they heard that he is the habitual offender and peddler Lordship. So he kind of Lordship doing business Lordship around this border area Lordship. So it attracts to 27A. And Lordship, and if 27A is attract Lordship, then 36A also attract under an NDPS. What is 37A clause 4 Lordship? In respect of persons accused of an offense punishable under section 19 or section 24 or section 27A or offenses involving commercial quantity, the references in subsection 2 of section 167 of CRPC, there to 90 days where they occur shall be construed as reference to 180 days. And was it provided that if it is not possible to complete the investigation within the said period of 180 days, the special court may extend the said period up to 1 year on the report of the public prosecutor indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the said period of 180 days. Notwithstanding anything contained in the court of civil criminal procedure, the offences punished under this act with imprisonment for term of not lost more than 3 years may be tried summarily. Lordship, then it addressed Lordship 37A also. So let's say Lordship, in this Lordship CD Lordship, his Lordship this forensic Lordship this they have sent a forensic expert also that report is still awaited. And Lordship, there may be some more investigation need to be conducted.
Your Honor, only hardened habitual offenders is not attracted at section 27 of NDPS Act Lordship. For 27A Lordship, specifically mentioned that punishment for financing illicit traffic and handling offenders Lordships. Whoever indulge in financing directly or indirectly any of the activities specified in subclause 1 to 5 of clause 7A of section 2 of Arbitration, any person engaged in any of the aforementioned activities shall be punishable with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to 20 years, shall also be liable to be fined which not be less than 1 lakh rupees, but which may extend to 2 lakhs rupees. From this statement of the co-accused or witnesses, is there any allegation that the present accused petitioner has financing to or instigate to or to financing the co-accused or to other accused to sell the drugs in the area Lordships? Though there no such
materials against this allegation, Lordship. And only for hardened habitual offenders is not that mean attack the section 27A. And so far as in Ranjit Kumar, Rakesh Kumar Singh, we State of West Bengal versus Rakesh Singh, allies Rakesh Kumar Singh, 22 leaves law, Supreme Court 586 Lordships, where it Honorable Supreme Court observed that the rigorous of section 37 Act will not apply in case where the applicability of section 27A NDPS Act is seriously questionable, and there was no recovery from the accused, and quantity in question. Quantity is question was intermediate quantity. In this case, Lordship, in our case, Lordship, intermediate quantity 10 grams of suspected to be heroin, Lordship, recovered, and only 16,000 rupees was recovered. This is not huge amount, or there is no such evidently proof that the accused person and financing to other accused person or any person to sell the drugs in the market, Lordship. That's my humble submission. I've already given copy my Supreme Court orders, Lordship, Calcutta versus. Amrita Singh Agarwala versus and Rakesh Singh allies Rakesh Kumar Singh, both are in same case, Lordship. From the possession of the Rakesh Kumar Singh, possession was recovered, which was intermediate, but Amrita Singh, there is no recovered from Amrita Singh's.
Yes, also recovery is done, Lordship. And Lordship, his confession statement is also there, Lordship, that he admitted that he has some businesses, Lordship. He had done peddling, Lordship, across the border area, Lordship. Then that is what is enough, Lordship, for evidence, Lordship. His statement only, Lordship, he has confession, made a confession.
Already 91 days behind the bar, Lordship.
Border area.
Lordship.
What do you have said?
Lordship, in accused statement, Lordship, he confessed that he has done this, Lordship, this business, Lordship, this peddling, Lordship, across the, Lordship, this border area. Lordship, one name is also reflected, Lordship, in his statement, one girl, Lordship, that in behest of her, he is doing this thing, Lordship. And as per this CD, Lordship, that girl has still, Lordship, there is need to be interrogation, Lordship. So 90 days not enough, Lordship. At least, Lordship, some more investigation to be done.
Chief upon the land council for the petition also heard Ms. Manhagi did an additional people appearing in the state respondent. CD received along with the statement of witnesses recorded by the under section 161 service. It is submitted by the land council for the petition that
Lordship, this consumer, Lordship, is this peddler is more dangerous than consumer, Lordship. By doing this, they have affecting lots of people, Lordship, this young generation, Lordship. So now this capital companies, lots of cases there, Lordship. Because of this, they have doing all those things that affecting, Lordship, the students, this youngster, Lordship. This consumer is, Lordship, they have kind of rehabilitation, they can go for rehabilitation, but this peddler is more dangerous.
is submitted by the land council for the petition that the present case is registered under section 21 or
21B and 27A.
21B and 27A of the NDPS Act. However, the accused is behind the bar since last 91 days, and there is no material to attract section 27A. 27A. It is what is submitted that he further relied on the judgment of the Honorable Calcutta High Court.
Yes, Lordship.
Honorable Calcutta High Court. wherein on the Honorable Calcutta High Court passed in Amrita Singh alias Agarwal's case, wherein it is held by the Honorable Calcutta High Court. Wherein it is held on the judgment of Honorable Kolkata High Court, wherein the petitioner, the appellant was allowed to go on bail. Though the case was registered under section 21B, says 29, says 27A of the NDPS Act. It is further submitted by the learned counsel for the petition that from the plain reading of the FIR, also it reveals that the petitioner may be a peddler, but there is no materials that he there was any but there is no allegation of harboring or financing any other person or co-accused to attract section 27A of the NDPS Act. Thus, the case also does not attract the 37 of the NDPS Act to consider the bail application. Also does not attract the section 37 of the NDPS Act. Further, it is submitted that the accused is a permanent resident of the address locality, and hence there is no chance of absconding if he is granted with if he is enlarged on bail. In this context, the learned additional PP MSL has submitted that the petitioner is not only arrested in connection with this case, but he has other cases where the other sections.
No, that's the Gopur Lordship.
In this record, also.
Gopur case number 1213/2022 Lordship.
He's not only the accused of the present case, but he was also a case arrested in connection with Gopur PS case number 213/2022 under section 365/307 IPC, read with section 120B/15(1)B Arms Act. This is pending. Case is pending.
Lordship.
Before Gopur Lordship. Assam. Yes, Lordship. And in this case, so far as my knowledge, the main accused is different Lordship. Some Shankar Palia Singh. He was on the basis of statement of his that present accused petitioner was sound as by the Gopur PS Lordships.
Pending report, pending in the, it is not charge sheeted.
Not charge sheeted.
They are arrested in connection with this case.
Yes, no, Lord.
Huh?
Not charge sheeted till date.
But he is also arrested in connection with that case also.
Shown as calls Lordship. When the shown as.
Is still
Shown as on 10/6/2023 Lordship.
shown arrest in connection with the safe case. Further, it is submitted by the learned additional PP that he is not a consumer but a peddler and involved, and also he used to bring the border area.
Lordship.
Was to bring the contraband from the border area, and if such kind of habitual offender is allowed released on bail, it may affect the entire society.
36A subclause 4 is attract Lordship here.
Huh?
36A subclause 4, Will accept.
society and 36A. Subclause 4 is also attributed in connection with this case, wherein the prosecution has the authority to extend the, can extend the period of investigation up to
180 days.
180 days, and even it can be extended up to 1 year. Further, it is submitted that that can be brought to next one, and hence it is submitted that the petitioner should not be allowed to go on bail at 6 days, and for the interest of the investigation purpose, his further detention may be required. It is further submitted that the FSL report is still awaited, and hence, considering this aspect, the bail petition should be rejected. Next point. After hearing the submission made by the London Council for both sides, I have perused the case diary and the statement of the witnesses recorded by the IO in connection with this case. From the statement made by the witnesses, it is seen that how many statements are there? These are the police personnel.
Yes, Lordship. Yes, Lordship.
Is there any individuals, witnesses?
In that the IO,
IO is the complainant, Lordship here. IO is the complainant, Lordship.
the IO has recorded
Independent witnesses is also there. Their statement also been recorded.
3 witnesses in connection with this case, and all the witnesses are seems to be decision witnesses. And from the statement of the witnesses, there's no material. There is no material, and no material is found in the statement made by the witnesses that which can affect section 27A of NDPS Act. It is a case that as per these witnesses, the intermediate quantity of contraband was recovered from the possession of the accused from his rented premises, but there is no mention about, there is no mention that there was any, but there is no mention that the accused was financing directly or indirectly, or he was harboring any other person for the such, or to carry out the activities of peddling and the contraband. Thus, it is seen that there is there is no material so far collected from the, thus it is seen that the material so far collected by the IO. The case is not established under section 27A of the NDPS Act. And thus I found NDPS more so, it is seen that the IO got sufficient time, more than 91 days for investigation. But till that, the IO failed to collect the FSL report, and also the progress of the investigation is still not progressing as expected. So considering all these aspects of the case, I find that the case, I find this case to be a fit case where the bail can be extended to the accused petitioner. And accordingly, so and so going to go 20,000 with 2 CVT. 20,000 with 2 CVT bail amount is 20,000 with 2 CVT to the satisfaction of the landlord. It is can be for special judge.
Special just NDPS UPA.
Session judge.
Special just NDPS UPA.
Special judge and DPS to the satisfaction of with the following condition, put some conditions there. And one condition was given that if there is any violation of cooperation also give you, he will also appear before the IO as and when required. And one more condition, we put one more condition that if any condition is violated by the IO, this bail will be automatically cancelled.
Obliged, hardly obliged.
Actually, there is no material at all. We have checked 27. Not at all, not a single line is stated.
Lordship, they have said, they have like submitted that there is a parallel lordship, they got to the, because this recovery is done lordship in front of them lordship. And lordship during integration also, only lordship, they have
Recovery
found
was there, didn't very Caesar replaces.
lordship,
This person.
lordship.
No, at least that he was earlier used to finance someone or.
It's for your reason.
Item number 4, I'm not going to hear. You are
Yes, Your
going
Lordship,
to
it's fixed
argue
for-
matters.
Fixed for hearing, Your Lordship, admissions for admission.
Admitted and
Yes,
will be
fixed for hearing, Your Lordship. Since there is already an interim, Your Lordship.
Interim was there,
Yes, ma'am. So,
heard your Mr.
The other man,
Heard Mr. D, no?
the other, yes.
The other, the Learned Council for the petition also heard. Mr. E, the Learned additional PP appearing on behalf of state respondent. Considering this submission made by the Learned Council for the petition, the matter is admitted for hearing. Scan copy you have received? No. We have not received, no?
this can copy.
Matter is admitted for hearing. Issue reminder calling, issue reminder for the scanned copy of the LCM. Poster. Let the matter be listed for final hearing on the receipt of the LCM. Scanned copy of the LCM. In the mean, further, the interim order passed earlier shall continue till next date of hearing. Listing. It will
Obliged.
be listed after receipt of the LCM.
Yes.
Because time cannot be fixed.
Yes, sir.
Item number.
This
Yes.
appeal is against conviction of the accused person Shri Tashi Bapu, who has authorized the appellant herein to move this instant appeal, and the authorization is at page number 27(1). If I may be allowed to refer the convicted person as appellant in this case. I'll be referring to the convicted person as appellant, Your Honor, but the appellant is different. He is a cousin brother of the convicted person who's been authorized to move this appeal.
No, I'm not getting it.
Your Honor, in this particular case, the accused person is Shri Tashi Bapu,
Yes.
who has authorized the appellant, that is Nimaj Ring Bapu in this
Acha,
case,
acha.
and he has moved the appeal accordingly.
Yes, yes,
So I may be allowed to call the convicted person, refer to him as the appellant.
yes. Mane, she is not the convict.
He's not. the
I mean,
convict.
he or she, whatever, she
No,
is not the
no,
convict.
Your Honor. Your Honor will find the impugned order of judgment passed by the learned special judge NDPS Bomdila at page number 28, annex number 2. Your Honor may kindly come to page 29 of the judgment. Accused number 3, Shri Tashi Bapu.
Hmm.
Accused number 3, this is the convicted person that we're dealing with in this instant case. He has been convicted under section 20B2A, that is for possession of cannabis, section 20A and section 27A, that is for possession and consumption of contraband substance, that is heroin, and for small quantity. And under section 27 capital A of the NDPS Act.
What was the term of conviction?
The terms of conviction are for 1 year with a
10
fine of 10,000 for section, under section 21A, 27A and 20B. And for a period of 10 years with a fine of rupees 1 lakh under section 27A of NDPS Act. Now, if I may take Your Honor to the FIR, Your Honor. That is at page number 60, 62. If I may read.
But this is, the matter is on for admission hearing, so you are on IA.
I am on my appeal, Your Honor, along with the IA. The IA is for suspension of the sentence and
Yes,
conviction.
but by the way, is there any LCR or paper book, whatever is there?
No, my lord, this matter has been listed for the first time. So if they wish, my lord, they can press for the IA, otherwise.
Otherwise, most probably by the last order, most probably the informant who was asked to make party by correcting the cost item.
Yes,
Whether
yes.
the
yes,
informant
Your
has
Honor.
already been.
He has been made a party. Your Honor, in this case, although the accused person has been convicted under section 21A and 27A of NDPS Act, there was no FSL report that was sent.
No FSL.
No FSL report can be found. Without the FSL report, he has been convicted under this sections. And with regard to section 220B 2A, that is with regard to cannabis, there has been violation with regard to section 50 of NDPS Act, because it is an allegation that the contraband substance has been recovered from the possession of the accused person, but he was not given any notice. Your Honor will see from the deposition of the IO itself.
Those are, for I also, if you need any, you have received the, any.
Yes, my lord, I have received the copy.
Received a copy means
Received the petition copy of IA.
petition copy of the.
IA, yes.
So with the petition copy of the IA, it will be sufficient for you to, I mean, submit. If it is
So
okay,
they
then
have
you can clear
enclosed,
the IA, or otherwise it can be posted,
it can be done, my lord, since they have enclosed all the materials.
all the materials.
Yes, my lord.
Okay, okay. So we are going to hear on the I, not the appeal. Appeal we will come on later on. So now your first point is there is no FSL report.
No
And
FSL
then
report.
Then
And the second is that they have not complied with the mandatory procedure as laid down under section 50 of the NDPS Act.
50
Section
or 52, 50,
50.
of the NDPS Act. And then
And moreover, Your Honor, there is inconsistency in the prosecution evidence as well. According to the charge sheet, the contraband substance were recovered from the accused person on 26th of June 2020. However, it was the seizure memo was only signed by the magistrate on 28th.
yes, Minister.
That the seizure memo was signed by him only after 2 days.
Hmm.
That means it was not, the seizures were not done in the presence of the executive magistrate.
Which was seizure was not done.
Yes, Your Honor.
But thereafter the seizure list or seized materials were produced before the IO, or
It was produced before the executive magistrate, but there is inconsistency in the statement. The executive magistrate has stated in his deposition that the color of the substance was of white color. But then in the FSL report, it is clearly mentioned that it was orange color. Moreover, Your Honor, the learned trial court below, while convicting the accused person herein under section 27 capital A of NDPS Act, has stated that he was harboring co-accused Deep Jyoti Patra, who has already been acquitted in this case. And if I may read the FI, Your Honor, will get to know the gist of the case.
harboring one, Deep Jyoti.
Deep Jyoti Patra. And only on the basis of that allegation, the learned court below has convicted the accused person. If I may read the FIR. With due respect and most humble submission, I would like to inform you that on 26 June 2020 at 1400 hours, on receipt of information from a reliable source at PS Bombilla that one suspected to be drug peddler, namely Sri James Tenzing Rijiju of Bombilla, is trafficking a huge catchment of narcotic drugs from Assam to Bombilla through Balupong with help of one Sri Tashibai. Accordingly, self with OCPS Bombilla and team of Bombilla PS staff left PS and intercepted on Sri Tashi on highway, who was found coming on a scooty bearing registration number so-and-so. On being searched, 7 vials of narcotic drugs, heroin, recovered from his possession. On being examination, Sri Tashi revealed that Sri James and sent him with the recovered drugs to sell it in Bombilla to the addicted persons on rupees 5,000 only per vials. Further, he disclosed that Sri James had financed the other party in Assam to procure the said drugs. Accordingly, on being led and shown by Sri Tashi, suspect Sri James apprehended from Balapong and a vial containing suspected to be narcotic drugs, heroin, recovered from his possession. Further, Sri James revealed that on 26 June 2020, he had sold 5 vials of suspected to be narcotic drugs, heroin, to Sri Tashi Bapu and led us to show the place where they were consuming such contraband drugs. Accordingly, Sri Tashi Bapu with one Sri Deep Jyoti Patra were apprehended while consuming such drugs at the house of father-in-law of Tenzing Ki, late Sanjay Leta in Upper Bhalapong. Hence, all of them has been apprehended. Now, in the FIR itself, it is written that the accused Sri Tashi Bapu and Deep Jyoti Patra were apprehended from the house of father-in-law of Sri James Tenzing Ki, who is an independent witness herein. So if they were found in someone else's house, then how could the accused person be harboring his co-accused? So without considering this into the picture, the learned court had convicted the accused person under section 27A.
Since when he is in custody? I mean, jail.
He has been in custody since 15/6/2020, after the 23, after the pronouncement of this judgment. 15/6/2023.
23. And during the entire trial, he was in,
He was
on
in
bail?
prison. He was in prison for a period of 1 month and 22 days.
No, now it is 1 month and 22 days. Otherwise, during the entire trial, was it in bail?
Yes,
Or
Your Honor, he was out on bail.
It was on bail.
He was on bail. And while he was out on bail, he has not violated any of the conditions that was laid down by the court.
Yes, Mr.
My lord, in order to consider an application number 389 of CRPC, firstly, there has to be a careful consideration with regard to the materials on report. And secondly, it has to be seen whether there is any possibility of succeeding the appeal or not, my lord. My lord, in the present case, after completion of the investigation and forming an opinion by the investigating officer, my lord, the charge sheet has been filed against 4 accused, my lord. May I take my lord to page number 64? My lord?
64.
64 of the main petition, my lord. Particulars of the accused person charge sheeted. Serial number 1, Tashi Jerang alleged Tashi Bai. Place number 65. Tenzin Thardong Rijiju, accused number 2. And serial number 3, Tashi Bapu, he is the present appellant who is before my lord. And the 4th one is Deep Jyoti Patra, my lord. And now secondly, may I take my lord to place number 69. The last paragraph of the base 69, last paragraph. Under the above fact and circumstances, a prima facie case is formed well established against the arrested accused alias Thardun Rijiju under section 21A, 27, 27A, stroke 29 of the NDPS Act for selling, consuming contraband drugs and engaging co-accused Tashi Jerang to sell it in Bomdala. Under section 21A, 27, 29 of NDPS Act against the alleged accused Tashi Jerang alias Tashi Bai for possessing, selling and consuming contraband drugs. Now this one is the present appellant one. Under section 21A, 27, 29 of the NDPS Act against the alleged accused Tashi Bapu. Now section 21A deals with a small quantity which is
charged it only under section?
section 21A, 27 and 29. But later on, the trial court has altered the charge and convicted under 27A.
Oh, yes,
capital
has been
A.
altered.
Yes,
Acha.
altered by the judge.
Initially, he was on 21A.
21A, 27
27
and 29. 21A deals with a small quantity punishment for RI for 1 year,
Consuming it. Yes.
and 27 deals with the consumption, and 29 abatement and criminal conspiracy. And altogether, in this case, 9 prosecution witnesses were examined and recorded the striking. After completion of the trial proceeding, my lord, the present appellant accused was before my lord was convicted under 27A for a period of 1 year, 20B clause 2 subclause A for 1 year, 27A for RI for 10 years, my lord. Now, may I take my lord to page number 97. The prosecution witness number 4. This can be very vital and crucial in deciding the present appeal, my lord. Page number 97. He is the only independent witness in this whole case, my lord. I am appearing in the court as Jimma witness as well as an oral witness in the case. When I was coming from Sepa to Bomtla on a scooty, the accused so-and-so asked me to leave at Nag Mandir. At that time, I did not know his name, but now
PW3 or?
PW4, page number 97. or not. I am appearing in the court as Zimmer witness as well as oral witness in the case. When I was coming from Sepa to Bomdla on a scooty, the accused so and so asked me to live at Nag Mandir. At the time, I did not know his name, but now I came to know his name. I accepted his request and both of us were coming towards Bomdila. And on the way, I stopped the vehicle for urination. In the meantime, police arrived and apprehended the accused so and so. Police check our luggage. On checking of the luggage of the accused, Tashi Jarang police found contrabands in the container. Police recorded my statement. My scooty was seized and I took it on Zimma paper exhibit 7. This is the Zimma number of my scooty paper exhibit 7A is my signature so and so. Now this is the cross-examination by the counsel of Tashi Jarang, my lord. It is a fact that the police searched our body as well as luggage. And it is a fact that there was no magistrate except police at the time of a search. It is a fact that we were not asked by the police personnel as to whether search was to be made before the magistrate or not. It is a fact that I have no knowledge whether the recovered vials contain drugs or not. It is a fact that I did not know the weight of the seized articles mentioned in paper exhibit 4. My lord, this is the initial wherein basing on which the criminal law machinery was set into motion. So to my understanding, there's a total non-compliance of section 50 to my understanding, madam. Now may I take my lord to section page number 99, my lord, PW6, madam. I'll skip the examination in chief part. I'll take away to the cross examination, which starts from page number 103, madam. It is fact that prior to the apprehension of accused person, I have received input regarding the contraband substances. Today, I have not exhibited the information in writing before this court, but if court requires the same, I will produce before the court. I have mentioned the same in CS. On receipt of information, I informed magistrate to accompany, but he was preoccupied. Hence, I acted promptly as the information was instant. I have not mentioned said preoccupation of magistrate in my charge sheet as per the disclosure statement of Tashi Jarang so and so may shift or dispose of the contraband substance. Hence, I could not obtain search warrant and acted promptly. I have not mentioned in charge sheet about the said fact. The contraband substances were seized on being produced by Tenzin Thardor. I mentioned the same in Caesar list. There was no body search, hence I have not issued him notice under section 50 of the NDPS Act, which is in fact appears to be contradictory to the statement given by the independent witness, my lord. I have not obtained search warrant while raiding the house at Balapung where I have apprehended Tashi Bapu, Deep Jyoti Patra and Tenzin Ki as the information was prompted and there was no time to obtain search warrant. The charges was found on the hand of Tashi Bapu and the vials were found lying nearby, out of which 4 are empty, which they have already consumed. In this case, I have not seized any contraband substance from Deep Jyoti Patra. It is not the fact that Deep Jyoti is my informer who was already arrested in other case. It is a fact that after 2 days of seizure, I have placed the contraband substance before magistrate. During that 2 days, the contraband substance was with me, but I have not mentioned about the same in charge sheet. I have noted in case diary. I have intercepted the accused person in hilly area and there was no independent person nearby. Hence, I could not make an independent witness to the disclosure memo. It is not a fact that the money in the account of Tenzin Thardor is not the same proceed of contraband substance. There was no huge transaction of money. I have not mentioned in charge sheet when and where the samples were collected before sending the FSL. I have not prepared any inventory and I have sent all the seized contraband substance for FSL examination, my lord. Material was with me and I am in charge of Malkhana, hence there's no requirement if examined any other person. It is the fact, not a fact that I have sent the contraband substance for FSL examination after 2 months. I have sent the contraband substance for FSL examination instantly. I have sent the vials recovered from Tashi Jarang for FSL examination. I have not sent the vials recovered from Tashi Bapu and Tenzin Thardor Rijuju for FSL examination as contraband substances were too small for FSL examination. I have sent the charges recovered from the FSL examination. It is a fact that offense attracted against so and so or so and so. Now, my lord, if we see the cross examination down below, he has reflected that I have not mentioned in charge sheet when and where the sample were collected before sending the FSL, my lord. Therefore, there was a requirement as per the provision of section 52A for drawing of sample, my lord, which is totally in violation of the same. If my lord, this is judgment for the perusal of my lord. This is the Recent judgment passed in 2023. It's a very short judgment, so I'll read the whole paragraph. My lord.
Yes.
My lord, I'll read from paragraph 3. Simarjan Jeet versus State of Punjab. We make it clear that out of 3 accused who were before the High Court, only the present appellant has come by way of this appeal. The appellant was convicted by the special judge under the NDPS for short for the offence punishable under Section 15 of the said Act. The appeal preferred by the present appellant has been dismissed by the impugned judgment of the High Court. The case of the prosecution in brief is that the SI so along with other police officers were present at the bridge on the canal in the area of village Balakot for the purpose of patrolling. When they noticed that the tempo coming from the side of village Matran, they signaled the tempo to stop. The driver and other 2 persons sitting in the tempo were apprehended. According to the case of the prosecution, search was conducted in the presence of District Superintendent of Police of the tempo, which led to recovery of 8 bags of opiahs, which were concealed under tarpaulin. From each bag, 2 samples of 25 to 50 grams were taken out into 16% and residue of opiahs in the each bag was found to be 25 so and so. The learned counsel appearing for the appellant relied upon the decision of this court in the case of Union of India versus Mohanlal. He submitted that the prosecution is vitiated as the work of drawing sample was done by PW7 without taking recourse to subsection 2 of Section 52A of the NDPS Act. He also pointed out that the examination in chief of PW7 so and so, which shows that the sample were drawn immediately after the seizure. Para 7, my lord. We have perused the evidence of BW7 Hardeep Singh, in which he has stated that from the 8 bags of opiahs, 2 samples of 250 grams each were drawn and converted into 16 parcels. This has been done immediately after the seizure. In paragraph 15 to 16 of the decision of this court in Mohanlal case, it was held. Thus, it is manifest from the Section 52A, subclause 2, include that upon seizure of the contraband, the same has to be forwarded either to the officer in charge of the nearest police station or to the officer empowered under Section 53, who shall prepare an inventory as stipulated in the said provision and make an application to the magistrate for purpose of certifying the correctness of inventory, certifying photographs of such drugs or substances taken before the magistrate as true, and to draw representative samples in the presence of magistrate and certifying the correctness of the list of samples so drawn. So, to my understanding, my lord, 52 has not been complied with. Otherwise, my lord, the submission with regard to Section 42, to my understanding, it may not be applicable in this case, because since the police officer was inspector who has conducted search and seizure, my lord. That's all, my lord. Fine. In the meantime, my lord, the LCR may be called for him.
Your Honor, may kindly dispose of the IO today.
Let's go over. Okay. Let's go over.
Your Honor, may kindly dispose of the IO today by suspending the order of conviction and sentence.
Hard minus EY Vidya, we done a counsel for the petitioner appellant. Also heard Mr. J. Saving, we done a people for appearing on the status. This is an application in Section 389 CRPC, 389(1) CRPC. For suspension of order of sentence dated 15/6/2023, passed by learned special judge NDPS Bomdila for the Bomdila East coming district, whereby the present he is the He is the, not the convict. Appellant is not the.
Appellant is not the convicted person. He's authorized.
The
by-
convict is. Convict Sri Tashi Bapu was convicted under section
21A.
21A,
27A,
27A,
20B to
20 B, Roman 2, capital A, and 27A of the NDPS Act. And was sentenced to undergo RI for 1 year along with a fine of rupees 10,000 for convicted section 21A, comma, RI for 1 year with fine of rupees 10,000 for 27A, comma, RI for 1 year along with a fine of rupees 10,000 for 20 small b Roman, small Roman 2, capital A of NDPS Act. And RI for 10 years along with a fine of rupees 1 lakh for the offense punishable under section 27A. Punishable no, for section 20, convicted section 27A of the NDPS Act. And to undergo SI for 2 months in addition to sentence imposed in event of failure of payment of fine. This next paragraph is submitted by the learned counsel for the petition that that there is there is every chance of succeeding in the present appeal and in the connected appeal. And the learned special judge has passed the order without considering the fact that there is total non-compliance of section 50 of the NDPS Act. And more so, there is also no compliance of section 42 of the NDPS Act, vis-a-vis without any preparing the FSL report, the learned special judge has passed the judgment and order convicting the present convict, Mr. Tashi Bapu Mitigana. Further, it is submitted that though the convict was sentenced to, though the convict problem here, though the convict is also sentenced to undergo SI for an RI for 10 years and along with the fine of rupees 1 lakh for convicted section 27A of the NDPS Act, comma, but it is seen that the person whom he is alleged to harbor, that is the co-accused Deep Jyoti Patra, has already been acquitted from this case, full stop. Thus, it is seen that the judgment passed by the learned special judge is not tenable under the eye of law, and there is every chance of succeeding in the appeal. Further, it is submitted that the accused is a permanent resident of this address locality, and hence there is no chance of absconding if he is and allowed to go on bail by suspending the sentence imposed on him. It is further submitted that the accused convict was on bail during the entire trial, and he never jumped over any condition of bail during the trial. In this context, the learned PP, Mr. J. Sen, has submitted that it is a fact that there is non-compliance from the evidence of the PWs. It is very evident that there is non-compliance of 52 of NDPS Act, and the neither the scissor list or nor inventory was prepared accordingly as per proviso of section 52A of the NDPS Act. Further, it is submitted that from the independent, the only independent witness, that is PW4, also did not support the prosecution case. And however, it is submitted that there are, it cannot be held that there is total non-compliance of section 42 of the NDPS Act. He further takes reliance on a decision of Honorable Apex Court, passed in criminal appeal number 41443, 2023. Simranjit Singh versus State of Punjab, wherein the Honorable Apex Court has held that the work of drawing samples
There are 9 and 10.
Hmm?
There are
There are
9
nine.
and 10.
ultimately, if there is a non-compliance of section 52A, that can be one of the ground for acquittal. That is the observation of
Yes,
the-
yes.
wherein it is observed that if there is non-compliance of 52, section 52A of the NDPSA, it creates a serious doubt about the prosecution case. That the substance was recovered the substance recovered was a contraband, and accordingly, this may be a ground for acquittal. The para 9 of the state judgment read as under, if you put the para 9 here, 9 and 10, both 9 and 10. For next para, considering the entire submission made by the running counsel for good sales, and also considering the evidence on record and other aspects of the case. Basically, the non-compliance of 52A of the NDPSA, as well as inconsistency of the deposition of the witnesses. I further also considering the fact that the accused convict never jumped over the bail condition while he was in bail during his entire trial. Next one. Considering this circumstances of this case, I am of the view that this is a big case where, and I hereby I find it prudent to suspend the sentence passed by the Learned Special Judge NDPS Bomdila, dated 15/6/2023, till final disposal of the appeal, and accordingly allowed to go on bail for rupees 20,000 with one security like amount, with the satisfaction of the Learned Special Judge. To stop. So following condition, give some comments. With the above observation, the present I stands disposed. And main appeal, there's an appeal, criminal appeal, so and so. Here you call for the LCM.
Yes.
Hard so and so, call for the LCM. Appeal is admitted for hearing, call for the so and so.
Sure.
You take this one.
This is an appeal against acquittal filed by the state of Arunachal Pradesh. My lord, in this case, the service report upon 1, 2, 3, and 4 And as well as 5 are still awaited, my lord.
1, 2, 3, 4, and 5.
5 are still
Yeah.
awaited. Therefore, let this matter be fixed after 2 weeks.
So it is awaited, then
Yep.
when you have taken steps,
Yes,
Is
we have taken steps from the last.
it can be awaited for 2, 3
Yes,
weeks.
madam, yes, ma'am.
Item number 5, had this setting did not need to be for the appearing for the state appellant. It is submitted, the steps has already been taken for the respond number 1, 2, 3, 4, and 5, but for as per the office note, the service is still awaited. Let the matter be accordingly listed after 3 weeks.
Much obliged.
This is the
Here,
transfer
Lordship,
matter.
already, same similar matter already disposed of by this honorable court, Lordship. Transfer petition number 4 of 2023. This is transfer petition number 1 of 2023.
Between the same party.
Same party.
Now
There-
it will be,
Session court, instead of
Teju.
session court Teju, session court Pasigat.
Pasigat.
Here, in the transfer petition number 4, the matter was domestic violence case. Here, the
Here?
matter is guardianship application.
it is a guardian.
Guardianship application pending before district and session judge UPR. It has to be transferred to
Can be, it was a earlier transfer petition number 4.
4.
You have the
I
copy?
have the copy, Your Lordship. Judgment and order copy. Similar order can be passed. I think from the other side, they don't have any objection. It's a consensus.
Last,
decision.
last time,
Instead of, earlier he was seeking to get it transferred to Teju,
yes,
but as per your submission, it can be transferred to Pasika.
yes.
It will be
The
congruent.
last occasion, I have already submit that this two matter may be called
I don't know, but.
club, two matter club and
Can
transfer to
put that
Pasigat.
club, Yes,
Yes.
But
so
Again, today listed. I don't
Just a
understand.
minute, that it was not disposed of earlier, I think,
Notice so.
but it was not listed together, I think. That's why. We just check out, go to the dictation. of this. Go to the dictation of this one, you will pass the order on 25/7/2023. Similar order will be passed, except the nature of cases of the different, almost other things are equal. So it can be disposed of. The dictation, I don't know now dictation, who took the dictation, so we'll just find out and take the dictation. We'll just find out.
Lordship,
Will be disposed of and will be transferred to Pachigat instead of as paid to Teju.
yes. Much of.
Number 6 disposed of. Disposed of. We just find it.
My lord, in this case, the counsel of the petitioner has telephonically informed me that he has some health issues.
Yes.
Counsel for the petitioner has some health issues, so this matter may kindly be adjourned. It's after 1-2 weeks.
Then appears for the petitioner, however, it is submitted by the learned PP, Mr. J saying that due to some health issues, he is not in a position to appear before the court. To stop. Let the matter be accordingly listed after 2 weeks.
Much obliged.
No, I'm not going to hear any matter, but question is that whether there is, the service is completed already or still awaited for any.
Still awaited.
Awaited for whom? Because one most really he has appeared. You have appeared,
No,
huh?
my lord, the respondent has to file a reply.
Yeah, we are,
Respondent,
yes, respondent number 4.
or you are the petitioner.
Yes, I am for the
So
petitioner.
you are a respondent for whom?
Respondent number 4.
You are for respondent number 4 and
Yeah.
1, 2, 3. These are,
Your Lordship, I am for 3.
you are for 3.
Yes. For 1 and 2, there is a semi-council discussion. Land management.
One is, no, petitioner is actually.
Yes.
Petitioner.
Yes.
Srimati
Yes, my lord.
Yapa.
Yes, petitioner is Landi Yappa, my lord.
It is a case for under, against the 145 proceeding or what? So on that strength, you are appearing, you are for 1, 2, and 3.
No, Your Worship, I'm only for 3.
You are appearing only for 3.
Yes,
So
Deputy
there
Commissioner.
will be standing counsel for land management, na?
Yes, Your Worship.
And 4, you are appearing.
Yes.
So just 1 and 2, what happened? It is there are 2 standing counsel. Most probably 1 and 2 will appear. So notice is not yet served. What the office note says.
Notice has already been served. The respondents has to file the reply, my lord. But none of them
Who-
them have
number 1,
filed.
1, 2.
No, no,
Who will file the reply?
no, actually, last time respondent number 4 has taken time to file a reply, but none of them has
Okay,
filed
that
any
is
reply.
Okay, the number 4 is here. I'm on 1 and 2. What about 1 and 2? Is services completed on 1 and 2? Because it can be easily served because most probably the standing counsel is going to appear. Standing counsel will appear on behalf of so and so. So why? It is not yet served or not here, anything is here.
Yes, yes, my lord.
Yeah. Huh?
Yes, my lord, the service has been already served to the standing council for 1 and 2 also.
Where it is, with the office not dated which, in which date?
Yeah, in order dated 31, 2023.
30?
Yeah. They have
31.
appeared 30
One.
January, 2023.
Achha, standing council or they already appeared then. Okay, then, so 3, you're not going to file any, you're not going to file any objection or written reply?
Your Worship, impugn order has been issued by the Deputy Commissioner itself.
Achha, achha.
We have to seek instructions whether they are
Okay.
willing.
And what about 4 year, you have not filed any objection till now?
Lordship, for that, we still need some more time to file the affidavit. Because our client, we are still yet to procure some documents from him. Therefore, praying for some more time to file the affidavit.
You are Mr. K? K
Yes,
time?
I'm for petitioner, no, I'm
no, you're
appearing
Mr.
on
K?
D Nime.
Huh?
D Nime, NIMEY.
So and so you are appearing for K time,
Yes. Okay.
for the petitioner and also heard. You are Mr.
Titaka.
T. Takap, the learned counsel appearing on behalf of respondent number 4. And also heard Mr. So-and-so, the learned government advocate appearing on behalf of respondent number 3. From order dated 31, 2023, it reveals that the respondent number 1 and 2 has already represented through the learned standing counsel, Mr. D. Kamdak, and thus the services seems to be completed. However, the learned counsel for the respondent number 2 submitted that he needs some more time to take instruction and to file the affidavit in opposition. Prayer allowed. In the same time, the learned GP also submitted that there's some more time may be required for taking instructions. To stop. Allowed. Accordingly, the matter may be listed. You need 3 weeks will do or?
Yeah.
List after 3 weeks.
Much obliged.
Okay, my lord, the interim order may be continued.
Interim was there?
Yeah.
Interim order we
Yes.
continue till next.
Much obliged.
Itu upor tak ada ni. The flag doesn't move up. Or yes, for upper. So directly I'm listening. This is the limit. This is now 21. Na? 23, 22. Yes,
My lord, I am for the petitioner, man.
you are for the petition.
Yes, ma'am. It seems, man, respondent are not, respondent counsel is not here, man, not present today.
Not present today.
It seems, man, yes.
Yes.
Last occasion also, my lord, the respondent had seeking time for 4 weeks. man.
Huh?
In last occasion also, the respondent 6 times, man. For-
You had any interim, yeah?
Yes, ma'am.
Interim was there.
Yes, interim was there.
Heard Mr. Young, good name?
And those, you know.
Heard Mr. M.
M. Dojimar, on behalf of Deep Angima.
M. Dozy be appearing on behalf of T. Panging, the learning council for the petition. The none appeared on behalf of the respondent, though names of two advocates are reflected, councils are reflected in the cause list. The further as per order dated 8/6/2023, the respondents were given time for filing the objection for 4 weeks. That 4 weeks time was given. 4 weeks time was given to the respondent for filing objection. However, today they remain unrepresented. Post of let the matter be accordingly listed after 4 weeks. The interim granted earlier will continue till next date of listing.
All right.
Your Lordship, perhaps service is not completed yet. Wait for the service report.
11 is not filed by the state.
11, we are respondent, Your Lordship.
Huh?
Item number 11, we are respondent, Your Lordship.
You are respondent.
Yes, Your Lordship. State,
Mr. D. Gogoi was there, no?
yes, Your Lordship, petitioner.
None appears on call for the petitioner. Third, learned additional PP, Mr. E. Hete. To stop. Let the matter accordingly be listed after 4 weeks.
Oblige.
None appears on call for the petitioner, and list the matter after 3 weeks.
May I please, your
Number
lordship?
14, yes.
Here, as per office not lordship, service is waited. However, my brother has already filed, another brother has already filed for the respondent number 1. But
You are.
I am correspondent number 1.
One.
Yes.
So respond number 1 is already appeared.
yes,
And
2, I have to take a press statement.
For 2.
Yes, for 2.
My lord, I have not received copy of the petition.
I will submit, I will supply tomorrow itself, yes.
Heard Mr. M. But the learned council for the petition, and also heard Mr. T. Tapik, the learned edition, learned council appearing on behalf of respondent number 1. However, from the office note, it is that the service is still awaited for respondent number 2. Accordingly, the petitioner is hereby asked to take first steps on respondent number 2. In the meantime, the learned council for the petitioner will also submit a copy of the MMO appeal to the respondent number 1.
Yes. This after 4 weeks, Lord.
List after, according to the matter, according after 4 weeks. Okay, copy. of-
Yes, I will. Oblige.
All right.
Bill number 20. Bill number 23 is not appearing. One I is also there, no?
Yes, your lordship, perhaps on last occasion, this court has directed them to file application for condonation of delay along with the prayer for converting this criminal petition into criminal revision petition. They have challenged the impugn order passed by the learned court below, wherein their prayer for compounding offense was rejected, your lordship.
So they even appear.
They file in IA, your lordship, for condonation of delay. But
Filed in IA and in the same time most probably, whatever they are absent today.
yes, your lordship.
None appears on call for respondent for the petition. Needs the matter accordingly after 3 weeks, after 4 weeks.
Deeply obliged, sir.
So the day we heard half one.
Yes.
She raised only 2-3 numbers of issues most probably. So we are going to hear it today.
I understand the issues raised are that by relying on an agreement enclosed with the memorandum of appeal, the argument was advanced that the agreement was only with PPCL and not with us. There was,
So they were, the appellant was wrongly implicated actually.
I know.
So appellant was wrongly, as per them, appellant was wrongly implicated as per the agreement was not between the so and so. So as per their submission, the appellant was wrongly implicated as a party.
That is on the basis of this agreement that they have enclosed
Yes.
with the memorandum of appeal, I believe.
Uh-huh.
By relying on that, I believe that argument has been advanced.
Yes.
This,
The contract was as per their submission, it was simply, the contract was there to execute the work. Apart from that, there was no other contract. And there was no document that the NHPC is liable to pay the bill amount or whatever. These are the submission made by the.
the,
NSPC has not admitted the liability.
Huh?
NSPC has not admitted their liability to for payment because they have not executed any document agreement, neither their name is written in the work order, nor they have given any written notification. That's
The
why.
agreement was only for the
for the
executive
PPCL.
work.
To execute the
executive
work,
with PPCL,
with PPCL.
that argument is advanced, I believe, relying on this copy of the agreement, I believe. Yeah. The general conditions of contract.
Yes.
That has been, the argument is advanced relying on this document at page 29, I understand, the general conditions of contract.
Yes. It is on paper book, page 29.
I on the memorandum of
29
appeal.
of the 29 of the paper book.
Contract is not
Yes.
given in the paper book, it is in the petition lordship.
Hmm?
It is in the petition lordship. Contract clause is in page number 70. Oh. Lordship, sorry. lordship.
Okay, we'll reply, we are.
35.
I'm a bit confused, that's why I'm alert.
35.
The one which 35 is a portion of that.
30, 60, what is 65? 65 is WS
Yes.
and
Page number 35.
35, my lord, friend is relying, my lord,
35.
in the memorandum of appeal, my lord, not on the paper.
Okay.
35 is a part of it. कौन सा गोल्ड लाइक होगा? Oh,
This.
for that, there was no provision for subletting. That is the argument advanced, I understand.
Yes.
Okay, I will come to that. First, my lord, we'll have the memorandum of appeal, not the paper book. my lord.
Okay.
Memorandum of appeal, because it is the memorandum of appeal that the appellant have filed. Paper book is a record that have come that has been complied by the registry. Your lordship will kindly come. Now, my lord. Just a moment. Now this agreement, my lord, which has been relied upon to advance the argument that there was no, could not have been subletting, so they are not liable. That document was not even enclosed with the written statement. Not exhibited. So lordship cannot now, at this appellate stage, be called upon to have a look at this and the argument be advanced that in terms of it, there could not have been any subletting. We are liable only for payment to PPCL and not to me. That argument goes, it cannot. Only one, there were 5 plaintiff witnesses, 4 plaintiff witnesses, or 5 matter, and only one defense. That is at page 7 of the paper. Of the paper.
7, page.
7 of the paper. This is the only person that was examined as a defense. Today I am here in connection with PPCL and Pawan Kumar Jain, whereas NSPC has been made a party. During 2003, I was posted at Kambang NSPC for execution of civil works, and PPCL was entrusted with the construction under an MOU. I know PPCL, but none other else. I saw the petitioner coming to my boss for payment. That is the plaintiff I'm representing. But NSPC is not liable for any other party other than PPCL. We have no right to enter into convenience with PPCL for awarding contract to any other agency. I was attached to see NSPC and obtain short suggestions for him. I have never heard the NSPC authorities taking liability for payment to any agency on behalf of PPCL. No liability stands to PPCL to be paid by us, rather we are to get back some excess payment. During those relevant days, I was supervising, this is gross matter. During those relevant days, I was supervising the works. I have no proof to show at present that I was entrusted with the supervision of civil works, but by virtue of being civil engineer and in being employed in the department I was supervising. The highest authority in that project was PNP Singh, who was the chief engineer. There were 8 to 9 supervisors in that project. I am a graduate from Musapur Institute of Technology. Civil works included construction of trench sewer, intake, wheel intake, channel, distilling tanks, slip flushing test, headdress, funnel, 4-way, such and such, such and such. Next paragraph. At present, I am assistant manager civil. My will kindly note this. I have no agreement copy at present with me, with PPCL. The agreement was not there. I am not aware of under which clause of the agreement mode of payment was entered. Though I do not remember the clause in which mode of payment is entered, however, I know that there is a clause in which it is written that PPCL shall arrange all materials needed for civil works. The CNSPC was not mandatory to obtain any suggestions in any such, whatever it is, the agreement that has been relied upon by my learned friend to argue that my argument, our agreement was only with PPCL, and there was no provision there for subletting it to anybody else, that is me, then your lordship will not take into account because it was not agreed. One judgment on that matter. 2010 4 SCC 491.
Yes.
31. Relevant paragraph is 31. My lord knows all this, my lord. I'm just one small paragraph. How can my lord that document was not even exhibited? 31 at page 497. Under the law of evidence also, it is necessary that contents of documents are required to be proved either by primary or secondary evidence. At the most, admission of documents may amount to admission of contents but not its truth. Documents having not been produced and marked as required under the Evidence Act cannot be relied upon by the court. Contents of the document cannot be proved by merely filing in a court. Here, not even filed. So all these arguments and these judgments regarding privity of contract and all that goes. Because it was not there. And regarding, my lord, they should not have been imputed as party and all. If that was the argument, if your lordship their affidavit, written statement at page 92, page 92 of the paper. Case was like this, madam. Work order was placed with me by PPCL, with whom this NSPC has entered into contract to supply cement. That was the thing. I supplied that. Now, I made approach to the NSPC, since they were not doing this, since they were the main body, I approached them many times. They are not denying. In fact, they wrote to the PPCL to do the needful, make my payment, time and again. It's there in the paper book, which is there in the written statement also. In the written, what they have said, even if now PPCL agrees, then we can make the payment from his account, from PPCL's account. It was taking that into consideration the impugned judgment in the decree was passed. Because it is their statement, I will read it. It starts from page 92. And one more thing, your lordship will not there, it was not their case there, that they were not necessary party. They cannot raise it now.
During
Yes, during the trial, there was not even an issue. Carelessly done. At page 93, paragraph 10. They of course deny that they made any verbal assurance to make payment on behalf of PPCL, but they say at paragraph 10 that the statement made in paragraph 11 in the cited petition, the respondents offered the same ground that as and when received the application from plaintiff for dues payment, the same has been sent for consideration to PPCL authority as per deed of agreement for supply of cement, as has been done, for which the present respondent has nothing to do with the same. So whenever I made that demand, they have forwarded it to the PPCL. Now your lordship, at paragraph 94. Paragraph 12 and 13, I will just read. The statement in paragraph 13 of the incident case, the respondents have not denied that fax message was received from the Power Minister, Government of Arunachal Pradesh, but the respondents could not pay the dues owed by PPCL. As mentioned in earlier para, and the respondents again informed the matter to the PPCL authority for necessary action in favor of the plaintiff, and as such, respondents has to ensure for the PPCL authority. 13. That the above made in paragraph 14 of the said money suit. Number 60, the respondents on receipt of information fax message from minister sent a warrant letter to PPCL authority for immediate payment to the plaintiff, and it was further directed the PPCL authority to give their consent full within 2 days, failing which payment shall be made out of PPCL running account bill. That is their statement. But it is to inform that PPCL has not given their full consent, thereby respondents could not pay the same. This is the stand. Then it is pertinent to mention hereby that as part of contract for execution of all civil work between PPCL and NSPC, that without getting the full cost of PPCL, the respondents shall not pay anyone out of their RA bill. And it is further stated that if today also PPCL give their full consent to NSPC, the respondent is ready to pay the same out of RA bill. That was their stand. There was no stand that they were not necessary party and all this. This was the stand of the NSPC. And that is how all the issues were decided, my lord. The impugned judgment starts from page 125. It is taking note of this paragraph in the written statement, this order was passed. It is not that the NSPC has to pay it from that. The amount that was due to PPCL, you pay it from the running account of PPCL. Page starts from 125, page 145. From the discussions made above, nobody is disputing that I did not supply the cement. Even on quantum merit also I am entitled. Because they are not also, they only say that we cannot pay because the PPCL is not, has not agreed. Taking all this, my lord, page 145. From the discussions made above, it is clear that the plaintiffs made the supply. The main question is who is to make the payment for the same? It is not denied that PPCL made the demands as supported by documentary evidence. From the records, it is also revealed that in failure of PPCL to make payment, the NSPC can make the payment of plaintiff by running account bill, provided PPCL give full consent to the defendant 1 and 4. So that was not given, but ultimately they have taken a stand that if they give, they would have even now made the payment. They're taking into consideration the trial court has directed that you make the payment from the PPCL running account. Now I understand on the last occasion, there was this oral submission made that payment, all payments have been made to the PPCL. Minor will not even consider that. There's nothing like that in the written statement. There's no statement like that. So yet this appellate decision, your lordship will not consider that. So taking that into account, that written statement, paragraph 13, this order was passed. In my humble assumption, there is nothing now. Because now, the whole appeal was on the premise, relying on the deed of agreement in the memorandum of appeal. But it starts from, I believe, page number 29, I think. Starts from page 29. Was pressed into service to show that there was no, starts from page 29 in the memorandum of appeal. It is not there in the, because it was not exhibited. This has been relied upon. The whole premises is that in terms of this agreement, there could not have been any subletting. I am not liable. But that was not the case of the NSPC before the London trial court. In fact, they said, even if they give the agreement today, consent today, I pay immediately. Taking that into consideration, London trial court judgment, you pay from the pay. And this oral submission that all payments have been made, no money left now. The lordship will not even take into account. The written statement, nothing is there. And additional evidence, your lordship not order 41, rule 27 also bars it. Cannot be at the appellate stage. If your lordship, I will just, the Honorable Supreme Court has also said so. Okay. Order 21, rule 27, your lordship is seven. Production of additional evidence in appellate court. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. I don't need to manage your lordship is aware of this. Could not. Barred by law as well as the judgment of the Honorable Supreme Court. Because since the appeal was wholly premised on this agreement, appeal goes now. There was nothing wrong, my lord. PPCL, what was the agreement because, but there was a running account there. So they should have made the payment from. This is the only thing. These grounds they cannot take now. Written statement, there's absolutely nothing. No party, nothing is there. In fact, they have accepted it with approach. Whenever we have approached, they have, I mean, the PPCL, they have forwarded to the PPCL, and in fact, they have admitted in the written statement that if the consent is given, I pay now. So it is in that context the impugned judgment and decree was passed. This agreement cannot even be looked into, taken into. That's my humble submission.
For the convenience of the court, lordship, I have prepared one written argument of lordship because There was no full consent from PPCL, that's why we cannot payment. We are not disagreeing the fact that they have done the work and they are liable for payment. That is also not contradicted. It's quite admitted by the NSPC, and as and when they have written any letter to NSPC has forwarded on good faith to PPCL for payment. But PPCL has not given any written consent, anything to NSPC for payment. That's why payment was not made. Even now, they have filed arbitration case against us, against NSPC. So I have prepared a written argument.
So have you received the copy?
No. All these facts about whether arbitration is going on and the minor will not, that is not even connected with the minor will only
No,
take
for the
into,
convenience of the court. I'm saying.
minor will only take into account the material which is available on record. Subsequently, what has happened, I don't know. And my lord is not supposed to look into it. Written statement, evidence. Agreement, not exhibited. Simple as that. In fact, this should fail on the sole ground that the whole appeal was crafted on the basis of that agreement that has been enclosed in the memorandum of appeal, but not exhibited. Only on that ground it goes, madam. That's my humble service. Obliged, madam. My lord, I'm not privy to what is there in the written argument. What I'm submitting is, my lord, your lordship will not take into account anything that is not in this. Your lordship cannot. In fact, your lordship goes to the memorandum of appeal.
3, 4, we are there. This one is the argument. They, earlier that also she was there, we raised 2, 3 issues that they are not, they should not be made party. And arbitration, they are not liable to pay that. That is their most.
That is not the stand in the written statement. So your lordship will not take it up.
This one is also there. So make it see.
Obliged.
So by the way, I'm not related to court matters. Why don't you approach anyone for the road condition? I'm just going to supposed to talk to the chief. The chief secretary can be, what is the condition of it?
Yes,
So
yes.
pathetic.
Absolutely.
Yesterday, so I went